back in Anderson County. Great hospitality here. You gave us good weather driving in yesterday. You didn't promise good weather going home. We'll just have to wait to see how that is. But we're just delighted to be here. And I want to thank first the applicants who have made the decision to offer themselves for service on the Chancery bench. That is not an easy decision to make, and we honor and respect your decision to do that. We also thank the members of the public who are here, and we understand there's also folks who are watching us on the live stream, and we're delighted that you're interested in this process because these are your courts. These judges are from your community. They decide your disputes, and so the public should be interested in how this process works. And while he's not, he's in the back of the room now, we want to thank Judge Spitzer for swearing in, or actually it's probably his third oath of office. Our newest appointee, Ed Lancaster, is back with us again, and we're delighted to do that. He has taken the oath. He has challenged the rest of us to remember our oath, so we will do that. And I'd also like to recognize former Circuit Judge Don Elledge, who is a great judge, good lawyer, good guy, and for those of you that wonder how the people that carried the flag of Anderson County when they're away from home, he carried it very, very well. So it's good to see you. I need to thank John Jefferson and John Coke for their support in getting us here. We're at the right place at the right time. We found the courthouse, so our intrepid staff keeps us in the middle of the road, and thank you so much for that. And one other thank you is due to the folks here at the Anderson County Courthouse who have made us welcome. We certainly are impressed with the quarters. Some of us have had hearings in here before, and we're just delighted to be here. We worry sometimes that we're going to get stuck down in the holding pen but luckily we've avoided the holding pen so far. This is the time of the proceeding where I'm going to ask my colleagues on the commission to introduce themselves, and we'll start with Mr. Lawless on the far left, if you don't mind.
Far left, that's an unusual place to be. All right, folks, I'm Tom Lawless. I practice in federal court in Nashville primarily, although I do get over to this part of the world once in a while. And it's kind of nice to come back, and it's kind of nice to be around normal people, and I'll just put it that way, instead of in the Socialist Republic of Davidson County.
Always nice to be known as a simple person. Alexander Waters, I practice in Knoxville, Tennessee with Long Ragsdale and Waters. I practice mostly transactional real estate law, and just happy to be here. Great little drive.
Good morning, my name's David Perkey. I'm from Morristown, and I retired in 2019 after 38 years in state and local government as Governor Haslam's Commissioner of Safety and Homeland Security.
Good morning, I'm Hal North of the firm of Chambliss, Bonner, and Stoffel in Chattanooga, and I practice primarily civil litigation.
Kim Halper, the elected district attorney for the 21st Judicial District, which is Williamson County.
Good morning, I'm Keisha Waters. I'm the executive director of CASA at the Tennessee Heartland.
Good morning, I'm Ed Lancaster, retired former general counsel for Tennessee Farm Bureau, and before that 11 years in private practice in Columbia, Tennessee.
Good morning, I'm Brandon Pellizzari, Assistant District Attorney General here in Anderson County. Pursuant to the precedent set by General Helper, I will not be asking any questions today because this is my home district. And I did the same thing when Judge Spitzer sat before the Vacancy Commission when Judge Elledge retired.
I'm Burt Carter. I'm a general practitioner with offices in Coffee, Rutherford, and Cannon County. Pleased to be here. I tell you what, I've been so impressed this morning with the security here. I love going into places where everybody's so daggone nice, and this has exceeded my expectations. I really appreciate it. You guys have got something to be proud of here.
Thank you. And I'm Bill Koch. I'm the dean of the Nashville School of Law, and I have to try to keep these people in the middle of the road, which some days is easier than other days, I'd have to say. Yeah, can't find the middle. We, all the members of the commission take our impartiality very seriously, and we take the appearance of impartiality seriously as well. And so in the executive session that we hold before this meeting, we raise and discuss any potential questions that any of us as individuals or a group might have about the ability of any of us to fairly sit on this hearing. In other words, are we so strongly favor against someone or against someone that we can't be objective? And we've had that discussion, and we have no such conflicts of interest today. We also will identify matters that could raise a question that might cause someone to be concerned about the appearance of impartiality. And when those arise, we announce it to the group, and we will announce it today. And any applicant who has a concern about any of us sitting is perfectly welcome to suggest that we not sit. Lightning will not strike if you do that. Matter of fact, there's several of us here that would be happy to go out and you know, go have some breakfast somewhere rather than do this. But it will not be problematic if you have a concern. And for example, one of the applicants today in their application materials discussed a case that they had where they were representing a litigant named Debbie Koch, K-O-C-H. I'm married to a Debbie Koch, K-O-C-H. It is not this applicant's client. So I just want to make sure, though, that anybody that reads the papers and say, my heavens, is that related at all to the chair of the commission? The answer is no. Is there anything else that anyone wants to disclose or needs to disclose? Doesn't look like it. Well, then let me just quickly explain the process so you all know how this is going to work today. We switch between alphabetical order and reverse alphabetical order in terms of the the applicant presentations. And we are going in reverse alphabetical order today. It's just the luck of the draw. What we'll do, we'll ask the applicants, each of the applicants, in reverse alphabetical order to make a brief introduction, up to 5 minutes. General Helper has prosecutorial authority and the time cards. Honor the time cards. If you get, as we heard earlier, if you get the red card, gracefully wind up and sit down. So you'll have the 5 minutes for introductions. The applicants may give part of that time to others who will speak for them, and that's perfectly fine. We're welcome to do that, but we do have 5 minutes. After all the applicants have spoken or introduced themselves, we are going to give an opportunity to anyone who is here who wishes to speak against one of the applicants to take the podium and express their concerns about that applicant. It is uncommon that happens, but it happens enough where we need to mention that. We will then, if that does happen, we will give the applicant or applicants who have some opposition the choice of either responding immediately to those concerns or wait to respond to them when we have the individual interviews a little bit later in the day. After that process, we will then begin our conversations with each of the applicants in turn, again in reverse alphabetical order. It is our custom prior to this interview to assign one member of the commission the opportunity to talk to an applicant individually, just to get to know them a little bit better, to dig in a little deeper behind the application, just to find out more about the applicant on a more personal level. I make those assignments. We do them at random. There is no method in my madness in terms of those assignments. The persons who are assigned are not viewed as advocates on behalf of the clients. They're just really there to, number one, help the applicant understand how this process works, to give them any advice that they may seek on how our decision-making process goes. And those persons who did the pre-interview will lead the questions. They will begin answering or asking the questions when it's time for individual interviews. You may find in this process today that some members of the commission may have no questions. Do not construe that as being disinterested. Do not construe that as being checked out. Do not construe that as leaning for or against one way or the other. As a practical matter, many of the questions get asked and there's no need to repeat them. So if any member of the commission says, I don't have any questions, you know, for example, Mr. Palazzari's already told you he's not planning on asking questions. That's not because he's not engaged. It's just that he is trusting the rest of us to bring out whatever it needs to get out. After those individual interviews with each applicant, we will immediately take a vote. The law requires us to take the vote in public, so we will take the vote in public. There are 10 of us today, so it will take a positive vote of 6 or more to move on to the list of 3 that goes to the governor. We will immediately take that vote. If all 3 are selected on the first vote, then our work will be over. If other voting is needed, we will then take a recess, go into executive session, and then return and vote as many times as we need to until we have 3 applicants to send to the governor. Unless there are any questions, we're ready to begin, and I believe that the first introduction will be Mr. Terry.
Good morning, ladies and gentlemen. My name is Jim Terry. I'm from Scott County, Tennessee originally, but I have been a resident of Anderson County for the last 27 of the past 31 years. After graduating college, I worked in the medical field for a few years and then decided to go to law school. I went to Indiana University. After graduation, I ultimately returned back to Tennessee, moving back to Anderson County. I started my law career here in the county, and ultimately worked in both Anderson and Scott County. I did that for several years. During that time, I had a chancellor ask me to come into his office for what I thought was to be scolded, but that was to encourage me to run for judge someday. And that encouragement has stuck with me all these years. I ultimately went to work for First National Bank of Oneida as an attorney and senior credit officer, so I got some valuable experience there, dealing with many things, especially lawsuits and interpreting federal regulation and creating policy procedures for the bank. After a few years of that, I decided I want to focus primarily on real estate, and upon leaving the bank, that has been my career since then. I've been pretty much dedicated to real estate matters, although I still have been taking cases, matters of probate, divorce, and custody since that time. But during these past few years, I've never felt that it was the right time to run for judgeship. Of course, the only judgeship that I would ever considered would be Chancery Court, because I think it best suits my experience. And so when this opportunity came up, I felt in my life that it is the right time to make that decision and hope for the best. But it's my desire, if I am appointed, to try to be the most fair and equitable judge that I can be, regardless of your gender, your religion, your politics, your socioeconomic status, or who the attorney is on the other side. And that's what I want to, that's what I hope to be and provide the citizens of Anderson County. Thank you.
Thank you very much, Mr. Terry. Mr. Housen?
Well, first, good morning, Your Honor and Commissioners.
Good morning.
I'm Mike Mollenauer. I am happy to be here. I practiced law for about 30 years out of Knoxville, And Evan has asked me to come back to court. I didn't know what it was going to take to put me back in a coat and a tie and get back in the courtroom, but I've been here many times. I'm quite familiar with the courthouse. A number of years ago, I asked a trusted colleague to recommend to me an attorney who would work hard independently and also be able to hit the ground running. He recommended Evan Hauser. And in the 5 years that I worked with Evan, I found that he was diligent, that he was unintimidated in a contentious litigation environment, and yet somehow remained courteous and professional in all that he did. As I'm thinking about what you are probably most interested in, if I were in your shoes and selecting someone for a very important position like this, I would probably want to know and be reassured that Evan's integrity and his temperament always brought honor to the law firm. I thought I was proud to work with him and proud to have his name associated with me. Thank you.
Thank you, Mr. Mollenauer.
Thank you, Mike. For my opening, I'd like to tell you a little bit about who I am as a person, and for me, that starts with my family. I'm joined today by my beautiful wife, Stacy, and my outlaws, Debbie and Paul Owens. I also have my folks here, Gary and Colleen Hauser. Debbie and Paul have lived in Claxton community just south of Clinton Highway here for over 40 years. Paul spent his career at Y12, and Debbie was a school teacher here at Clinton Middle School. Stacy grew up here. She graduated from Clinton High School, and she went on to get her get her degree in finance and ultimately her CPA degree. And she has a CPA office just less than a mile here from the courthouse. My dad, Gary, was a civil engineer at TVA for over 20 years at the lab in Norris here in Anderson County, and he taught me my work ethic and he taught me my work ethic and also loved the outdoors. And when he didn't have us working at home during the summers on home improvement projects, he had us out in the mountains paddling, camping, and skiing. My wife taught me, my mother taught me the value of my faith and family. She insisted on church, a clean room, and is the glue for our family today. Growing up, I was active in my youth group and through high school, played sports through high school, and when I turned 16, I got my first job to help pay for my car insurance and my car. But for my first year of law school and the 6 weeks I took to study for the bar, I've had a job every day of my life since. When I went to college, my dad advocated for engineering, but I decided to switch to English because I received so much encouragement from my writing professors, and I decided ultimately to put those writing skills to test by going to law school. And when I graduated law school, I knew I wanted to be one thing in life. I wanted to be a dad, and I wanted to be a present father in the lives of my children. So you have in front of you my legal experience, but I'd like to tell you a bit more about how I've tried to order my life personally. As my children grew up, I was active in their lives. I coached their soccer teams. I played music with my daughter at her music recitals. And from kindergarten through 6th grade, I was the leader, or a leader, and then the leader of my son's Cub Scout program. I was blessed to say I was able to walk them to school every morning of their elementary school period. And then after 13 years of marriage, I suddenly found myself standing in the middle of a divorce. And honestly, it was the most painful experience of my life. But what I can say, and I think the mother of my children would agree, is that we put the best interests of our children at the forefront of our decision making through that process. I've since remarried, and I've experienced all the joy and challenge that goes along with blending a family in the middle of the pandemic. But I can say now, as I stand here today, my children are thriving, and if I can ride their coattails a little, my daughter is graduating high school on target to graduate the top 10% of her class, and she's signed to play tennis in college. My son is in 8th grade, and when he's not at tennis or at CrossFit with me, you'll find him at the chess club or at the writing club. And my bonus daughter, Stacy's youngest, she lives with us. She's currently in middle college, and she makes straight A's there, and she's on target to graduate high school with only needing 2 more years of college in order to complete her bachelor's degree. And my pledge to the citizens of this community, my community, if appointed chancellor, is that I will apply the same passion, focus, and energy that I have for my children when making decisions on behalf of the children of this community in their best interests as chancellor for Anderson County. Thank you.
Thank you, Mr. Hauser. Mr. Forrester?
Morning, members of the committee. It's an honor to stand before all of you here this morning, and I realize everyone here has probably actively read all the applications, and so part of my reasons for applying for this position go hand in hand with sort of as my legal career of how I've ended up here this morning. After being licensed in 2005, shortly thereafter, I started working actually across the road here at Ridner and Ridner, where there I started handling domestic relations cases, adoptions, terminations, conservatorships, criminal matters, juvenile matters, and then from there, after a period of time, I went to work right down the road at Fox and Farley, also here in Clinton, Tennessee. Where there, I continued to handle the same types of matters and worked there till about 2009, where from there I opened up my own law practice, which is literally one building from the courthouse here on Main Street, and that's where I'm still located today. And continually have had the same sort of practice, and as I put in my application, I do travel around extensively in this region to various counties, but by far and away, the majority of my practice has been in this courthouse. I've spent many, many hours here and have tried many cases, first in front of Chancellor Lantrip in the Chancery Court here, and then subsequently in front of Chancellor Cantrell. And even was happy to see Judge Elledge here this morning. I tried my first criminal jury trial in front of Judge Elledge years ago in criminal court right across the hall. And so even though I travel around, I have felt that I've sort of grown up in this courthouse as an attorney. I used to joke with the clerks at times here because, and this is not an exaggeration, there are times every week I'm in this building probably 3 to 5 times a week. And also as going through this process started thinking, and I realized that I have been practicing here quite a bit longer than all of the judges that we now have currently in this county have been seated on the bench. Now, I've known them longer than they were judges, but it's interesting that I've realized I'm starting to be here quite a bit of time. And I say that leading into both of my children have always been involved here. I'm a very proud father, and my daughter actually asked me repeatedly if I was going to mention her this morning. She's a 5th grader at South Clinton, is an A honor roll student, and I have a son who's went all the way through the Oak Ridge school system. He's now a junior at Oak Ridge High School. I'm a very proud father with 2 wonderful children that have grown up here in the community, and all of our involvement, our friends, our associates, the things you would have associated with your family, the things we sponsor and the activities we participate in are all here in this county. And so when I heard Chancellor Cantrell was resigning, one of the things that concerned me, and we sort of had to go through this recently too, unfortunately, when Judge Elledge resigned, and it was no fault of Judge Elledge's. Of course, when that happens, there's no judge for a period of time, and you end up with a backlog of cases. And what's happened here in this court is now orders of protection, which were usually handled by this court, are now being shuffled back to all the sessions courts, causing issues in those courts. Judge Spitzer's been having to step in as needed and sign emergency orders and handle things that he could. And now, while we have some interchange judges, things are not being heard. We're not really having trials, and so there's now starting to be sort of a log jam of cases in the Chancery Court. And so I felt it was very important that we had someone that could come in that understands the courts here in this courthouse, understands how they operate in relation to one another, and understands the general workings of Chancery Court. And I've spent an extensive amount of time and years there. And so when this became open, I felt sort of an obligation to the community and also to the local bar. I have a very active practice. I do not need to financially switch jobs, so to speak. But at this point in my career, I've been practicing for almost 18 years, primarily in this county. And I felt an obligation and also felt that it would be an honor to be able to step in and hopefully do as good of a job as Chancellor Cantrell did while she was here as Chancellor. And with that, I'm at 30 seconds. I will thank you for your time this morning and for the committee's consideration.
Thank you very much. Mr. Crutchfield?
Good morning. My name is Tim Bobo from the Ridner Law Firm, and Judge Don Elledge and I are going to briefly introduce Karen Crutchfield. I met Karen Crutchfield in 1995 when I got my first job at a medium-sized law firm in Knoxville, Tennessee. She was a year ahead of me in law school, although I didn't know her. She was one of these people that helped me transition from my illusions of what the law practice would be in law school to what it really is. She helped me with the fall that I had when I went from being a third-year law student graduate to practicing in the real world. She taught me that Betty at the courthouse is probably your best friend, who's going to tell you how to forget everything you thought you knew and to do it her way. Everything about Karen Crutchfield in my entire experience has been professional. She's been open-minded. She immediately took me under her wing at this firm, even though it was not her responsibility. She got me involved in coaching the Knox Catholic moot court team. We successfully did that. She transitioned into the corporate world as general counsel. I stayed behind, and then we would eventually meet up at various defense firms along the way. I have worked with Karen. I have worked competing against her to try to get insurance company clients. And then once I transitioned into a plaintiff's practice, now we have cases against each other and have for years. I've always known her to be open-minded, responsible, conscientious, very detail-oriented. But most of all, I think she really thinks of this as her community, and I think she wants to help, and I think she's got a very broad experience that is unique. She's done domestic relations, she's done guardian ad litem work, she's done corporate work, she's done wills, estates, property, insurance defense, litigation on both sides. So I think she's practiced successfully in the circuit court, in the courts of equity, and she has a very much a broad experience that I think uniquely qualifies her for this position. And now I'll turn it over to Judge Don Elledge.
Thank you.
Good morning,
It's
Chairman
good to
Cole
see you.
and Commissioners. I've got just 2 minutes, so I'm going to be fast as I can on this. I've been a licensed attorney for 46 years. The last 16 years of my work served as the criminal and circuit court judge just down the hall here. I knew of Karen Crutchfield before I became judge. While I was practicing law, I got to know her really well when she became an attorney who practiced every week that I was in civil court. I did civil and criminal. I found Karen to be well prepared, knowledgeable, kept up with the law, knew the facts of her case, or cases, and presented those ethically, morally, and professionally. It's Judge, as you know, it's a judge's dream when you have somebody like Karen come into the courtroom. That's my opinion of Karen. But let's look at some of the other opinions. I'm sure you've all looked at the resumes. Paragraph 25 specifically has bar associations and professional societies. Ms. Crutchfield had 12, and out of that she had 11 positions that she actually participated as an officer or otherwise. Paragraph 26, which I think is really important, this is what others really think of her. Other forms of recognition, professional accomplishments, she's got 20. Nobody else even answered that question except not applicable. She's got 20. She's qualified. Part of that, as an example, is the Fellows of the Tennessee Bar Association, she was inducted. Fellows of the American Bar Association, she was inducted. AV Preeminent Peer Rated for the highest level of professional excellence by Martindale Hubbell. Hearing Officer for the Board of Professional Responsibility. I'll hurry up. Ms. Helfer, thank you. Really impressive. For the last 8 years, U.S. News and World Reports, best lawyers in America, 8 times, 8 years in a row. Tennessee Supreme Court Justice Recognition 6 times. That's what others think about her. People who work with Ms. Crutchfield, people, judges, professionally, I couldn't ask for better. I highly, highly recommend Karen Crutchfield to go to the governor along with the other two. So she's got a child that's going to be graduating from U.S. Air Force Academy on March the 1st or 2nd, I believe. It'd be a great present for her. She deserves it. I appreciate it. I'm here as a citizen of Anderson County. I love the judiciary. I love the citizens of Anderson County, and I think she would be a great chancellor. Thank you.
Thank you, Judge. Mr. Brooks?
Good morning, members of the commission. I'm Jamie Brooks from Wartburg, Tennessee, is where I practice. I have ever lived in Oak Ridge for 38 years. I'm going to take just a minute, and then Judge Davis from Morgan County is going to come and make some remarks. I'll address maybe one of the elephants in the room. I'm the offender. It is my application that lists Debbie Cock. Sometimes maybe I get too down in the weeds and didn't realize, but I assure this commission it had nothing to do with knowing that Justice Cock was going to be the chairman. As you know from the application, there was a reason I referred to that case, and there's also a not stated reason that I referred to that case, and that is because those defendants became clients of mine and have been clients of mine for over 20 years. Debbie Cock I've not seen since the case was finalized. With that, I'll turn it over to Judge Davis.
Good morning.
Your Honor.
It's an honor to speak not only to this distinguished commission, but on behalf of Jamie Brooks. I've known Jamie for 37 years, and 24 of those has been since I've been general sessions of juvenile court in Morgan County. Jamie's been there and handling divorce, custody cases, orders of protection, also civil and criminal cases. And I've witnessed his skills and abilities in take cases of all types of complexity and length. And regardless of those, he's always been prepared, well-versed, and ready to go when he's come there. That's regardless of that length of time. He's had full knowledge of the law. In fact, what I find with Jamie is that he's not only helped the court many times on cases that he's not involved in, on advice about what the law is or just a sounding board, but he's also helped other lawyers, young lawyers, to come in and help them get started and lead them along the way. In addition to that, his legal skills, he's has great interpersonal skills. He's courteous to the court personnel, to my staff, to the other lawyers. I've never seen anyone, never heard of anyone, either at the courthouse or any other lawyers have any negative comments about Jamie Brooks. And I think he is the type of lawyer that any judge would be pleased to have in their courtroom. And to be clear about my confidence in Jamie Brooks and his legal skills and ability, he's the only private attorney that I've allowed to serve as special judge for me in 24 years. I think that should say it all, but I think his experience and his love for Anderson County will serve this county very well. And I thank you for the opportunity.
Thank you, Your Honor. Appreciate it.
You've heard from very many qualified candidates this morning. There's no doubt about that. I want to talk just a minute about why I think I am the most qualified. I have made my living in Chancery Court, in Morgan County, Anderson County, Scott County, Roane County, and other places for 37 years. The jurisdictions, of course, carry over to circuit court as well, but the types of cases that are filed in Chancery Court pretty much mirror what I've been exposed to and what I've practiced in the courts around this county and the 9th and 8th Judicial District. I know the workings of the court. I believe I'm very knowledgeable in the substantive law of the subject matters, and I'm ready to go day one. But I'm here not just because of my experience over 37 years. I wouldn't have taken this step without the support of my wife. We've been married 40 years, be 40 years in July. And she's my best friend, my partner in everything, and fully supports this decision. We've lived in Anderson County for 38 years. Our son grew up and went through the Oak Ridge school system. This is home. We attend church here. We are part of the community of Oak Ridge. And I never thought I would have this opportunity. I'm kind of a man without a country. I practice in Morgan County, but I don't live there. That's the 9th District. I could never run for judge. I never thought this opportunity would arise. I feel, privately, I wanted to do this for several years, and I feel the time is right. And I appreciate your consideration of my application, and I'll look forward to talking to you later. Thank you.
Thank you. We've reached the part of our program where invite anyone who wishes to speak against any of our 5 applicants to come to the podium. As they say, speak now or forever hold your peace. you can exhale now, no one is getting up. So that's good news, and if the commission's ready, we'll proceed to the interviews, and Mr. Terry, we invite you to come back up. And I believe Mr. McCarter is going to begin the conversation.
Good morning.
Good morning.
Hey, thank you for talking with me on Wednesday. Had a great conversation. Really enjoyed it. One of the things I didn't get the opportunity to ask you in our phone conversations, I noticed that you went to Indiana to law school.
Yes.
Why?
Well, that's easy. I was in the medical field before, as I said. I was on call one night in the at Baptist Hospital, and I was in the doctor's lounge, and I was kind of disgruntled because I was working a crazy amount of hours and didn't know if I wanted to go on and be a cardiologist or something else. You know, back in high school, I'd always thought of being a lawyer, but your family kind of pushes you in different directions. But this doctor was reading an article in the U.S. News and World Report, and it talked about health law. And it said Indiana University being one of the top in the nation. So I read that article, and I said, that's what I'm going to do, and that's where I'm going to go. So then I took the LSAT and applied and went to Indiana University. But when you get there, you kind of realize, well, the health law thing was really not, it's mostly theory, things like that. That's not what I really wanted to do. So I kind of moved away from that while I was there, but I loved attending law school there.
Talk with the commission a little bit about your background. You said you were talking with a doctor and you read this report, this article. Talk to them a little bit about kind of your career path and how you ended up in law school and what you were doing prior to law school.
Okay. Well, once I graduated, I had a degree in biology, a minor in political science, and a minor in psychology, and still was kind of on the fence. I was raised by two parents that never graduated high school. So, you don't have that kind of guidance you do from educated parents. Now, my parents worked hard and did well for themselves, but so I was still kind of figuring out what I wanted to do. But so I had plenty of friends in the medical field, nurses mainly. So I went ahead and pursued that, and I've got a nursing license. Then while I was doing that, I was working at Baptist Hospital and spending a lot of time being based in a cardiology office. And so one of the doctors there asked me if I'd want to come on board with him when I graduated and run the pacemaker clinic, where I would do the reprogramming and programming of all pacemakers. So I thought that would be great. So that's what I did. So I worked side by side with him during my career, and so anytime he was on call, I was on call. So, and working a tremendous amount of hours, not getting paid for it. So, and I knew I wanted to do something different. It's either go on and be a cardiologist, but most doctors at that time would try to talk you out of it, saying don't do that. And then that's when that thought of law school had always been in the back of my head. And then after talking to that doctor that night and reading that report, that's when I made a commitment to do that, and that's what I did. So then went to law school, Indiana, and then afterwards I spent a little time up in Batesville, Indiana, but my wife she got pregnant, and we realized we had no help up there, and neither of us liked it up there. We had no friends, no family where we were living, and we thought, well, let's go back to Tennessee. So she got her old job back in Knoxville or Alcoa, and then so I had lived in Anderson County prior to going to law school. So then we moved back here. She worked there, and then I started practice just right up the street here. So.
Talk to me a little bit about what maybe special skill set that you have that you will bring to this position if you're one of the three and ultimately selected by Governor Lee. What do you have in your skill set that's going to be unique to this position?
Well, I know that all these candidates are well qualified, so I don't know that my skills are really any more unique. I can speak to the, I'm pretty sure we all probably have some domestic relations experience. Most attorneys do. They have to start out doing that type of work, and some continue it. But I think, you know, a lot of the cases in Chancery Court, there are a lot of cases that involve real estate, and I think that that's where I might have an edge. I can't really speak to the other candidates' experience with that, but I do know that I think I have a lot of experience with real estate. I've taken a case to the appeals court over adverse possession before. So I think that's where my experience lies. Demeanor, I don't, you know, it's, I think that's important, and that's what the former chancellor that I mentioned had encouraged me. He said, you have the demeanor for it. You know, you can't treat people with disrespect. These people come in there, you know, they're already hurting or suffering from something, or they wouldn't be there. They're spending money they can't afford, most likely, and so they deserve to be treated with respect, regardless of their status or who the attorney is. But back to your question, I think that's what I can lean towards, and then my experience in banking, you know, that's a unique experience that I have as well. So dealing with a lot of federal regulations.
You know, I would presume that Anderson County is very similar to Rutherford, Cannon, and Coffee, where I practice, Bedford, those sorts of counties. I would presume that this position is handling a tremendous amount of domestic relations type cases. Is that a fair assumption that I'm
Yes,
making?
that's a fair assumption.
You said that maybe early in your career you were doing, or you had to do domestic relations cases probably to make ends meet and that sort of thing. Are you still actively doing any type of domestic relations type work?
Yes, I actually just had a custody hearing last week. So, and yes, I still handle divorces. I pick and choose, though. I'm at the stage in my life that I can pick and choose what I take, what I feel passionate about. So.
How much of this position is domestic relations?
Well, I don't know what the current percentage base is at this moment, but I would imagine it's 50% at least.
Do you envision, if appointed to this position, do you envision in those types of cases having a hearing the proof, making a ruling that day, or taking those types of matters under advisement? What have you seen, and what would a Judge Terry do in those types of circumstances?
I think it would have to be a very complex and challenging case for me to take it under advisement. I think most of those cases, with most of the cases that I've had in Chancery Court involving domestic issues, get a ruling that day.
One of the things you said earlier is demeanor. I'm sure you've been in front of judges that you thought, man, I would love to emulate, or I would like to be like that he or she. Talk to me a little bit about what you gained in your practice that you've seen that you would bring to the bench from a demeanor standpoint.
Well, I think that one of the judges that I would emulate, it actually was the former chancellor here in this county, and that's Chancellor Lantrip. And I guess he's not here anymore. Judge Elledge. You know, I always felt anytime I appeared in front of Chancellor Lantrip, win or lose, that I was treated fairly along with my client. And now there were times that you could see Chancellor Lantrip, you know, he was not happy about something, but for the most part, I always felt like that I was going to get a fair shake in his court no matter what. And I always thought that's the way it should be. Shouldn't matter if you've got a green attorney right out of law school or a high dollar attorney from Knoxville coming into that court, that he treated you the same. So.
No high dollar folks here in Anderson County?
Well, I guess what I mean is attorneys from another jurisdiction. Let's say that.
Carter, you don't practice here, okay?
To avoid the, you know, the old slogan, home cooking, you know.
things that Judge Elledge said when he was making his opening remarks about one of the other candidates was her jury trial experience. And you and I talked a little bit on Wednesday about maybe the lack of jury trial experience that you have. Could you talk to the commission, because if I don't ask it, one of these folks is going to ask it. How are you going to be able to acclimate to maybe a good friend of mine, Will Lockhart, who's a circuit court judge in Coffee County? Within his first week to 10 days, he tried a medical malpractice case and had never done that. How would you handle that, not having done a jury trial?
Well, I'd handle it the best I can. You know, I'll do some much needed quick research, even if I have to appear. You know, I've observed jury trials. It's not as though I've not had any exposure to jury trials. But yes, it's a fact. I don't have jury trial experience. It's not for a lack of not wanting one. I think most attorneys that appear in court want a jury trial at some point. But I'm also a believer that a jury trial should be the last resort. You know, you should try to get these folks to either come to an agreement, whichever method, either through mediation or through collaboration or discussion. But if that happens, I can promise you I'm not going to go on the bench unprepared. So I'm not going to wing it. I'm not one to wing it.
What would be Judge Terry's unwritten rules? What if I'm rolling into Anderson County from Rutherford County and I haven't had anything before, and I really don't know anybody in the local jurisdiction to call and find out about you? What do I need to know so I don't step into any booby traps when I come into your court?
Well, and I know you say unwritten rule, but I know it's a written rule. But it seems to have fallen to the wayside in my past is the ex parte communication. It happens too frequently, I think, and it shouldn't happen. And I would want, like I said, I would want an attorney coming from Rutherford County to know that you know, you're not going to get on the phone with me and have an ex parte communication. You're not going to come in chambers and have one. But at the same time, you know that you're not going to experience home cooking. You're going to be treated the same as the local attorney that's before me. So.
Any other rules that I would need to be kind of cognizant of?
Just be prepared.
You know, the majority of folks in here, I mean, we're lawyers, and the last thing we want is to come into a courtroom where the judge is giving you stink eye. You know, it's hard on you. I've got an 18-year-old, a 13-year-old, 11-year-old. My 13-year-old is going ballistic this morning because he's overslept, doesn't have his homework. I'm trying to manage that, be focused on you, and then I have to go try a case, and then I've got a judge that's being a little bit difficult on me, giving me stink eye. Are you going to be the type of guy that's going to give some stink eye?
I can't imagine so. That's just not demeanor. With that being said, I will take these cases seriously and treat them as such. But I don't think, I've been demeaned before, in court. My very first appearance in court, was used as a comedy routine, being not ever having been in that court before. But it's not fun. But I don't think any attorney should be demeaned or degraded in court or given stink eye, as you say. I think you should be treated with respect, and of course they need in return treat the bench with respect.
You mentioned young lawyer. Let's say you've got a young lawyer that hung his shingle. He really doesn't have a good mentor. He's just kind of out there trying to wade through the waters on his own, and you're on the bench and you see, man, John Doe does not have it together. He's doing a poor job for his client. What do you do in that circumstance?
Well, I mean, you can't be their lawyer, you know. I think, you know, I wouldn't say that I was unprepared, but I've been there in the early stages where you're nervous, you know, you're not sure what to do maybe, but, you know, maybe having a communication with both attorneys and maybe have a discussion about, hey, here's what's going on. You're gonna, you know, you're at risk of jeopardizing your client's interest here, and you know, you may just have to provide some coaching, but not overstep your ethical duties as well. So.
What do you do in your free time if you're not practicing law? What are your interests?
A lot of traveling, a lot of hiking, play golf, fish, live near the lake, so spend a lot of time on the lake. Probably 18. Yeah, it's not great, but yeah.
One over, I mean, so each other, there's nothing wrong with
Okay,
that.
so.
You weren't expecting that one.
Yeah.
All right, so I think you told me the other day you've got a girlfriend and at least one child, maybe.
Yes, I do have a girlfriend. She is a doctor in Knoxville. I do have 2 children. One's 18. He's a freshman at Tennessee Tech studying mechanical engineering. He graduated with honors from Anderson County High School. I have a 14-year-old. He's a freshman at Anderson County High School. He's a soccer player into TSA. He's an honor roll student. So, yeah, I have. It's been half time with them, and I make it an effort that anytime we're together that I spend a lot of time with them, and so yeah.
If I huddled with them back in the back corner, I said, "Hey, tell me about your dad. What does he look like on a bad day? What are they likely? What are they likely to tell me?"
Oh man. Well, if you could get my oldest one to talk to you, that would be the.
I can talk now. I'll get him to talk.
I don't know. He's the shy, quiet type. But my youngest one, it's untelling what he would say. He'd probably say that no, he can't stand to be around me then on a bad day. But you know, we have an excellent relationship. There's not too many bad days. You know, when I have my child, I try not to. You know, even if I'm having a bad day on the inside, I try to make sure he don't know it.
So, let's say you don't get appointed to this position. Will you run for this position in 18 months, whenever the next election is?
At this moment, I can't answer that because I don't know what my status will be. You know, come that time, you know, I could say that I am perfectly happy at that time. I'm happy now. I have a very good practice. I think one of the candidates said it's not a money issue for me. I didn't even know what the actual salary was when I turned my application in because I don't want to I never make decisions based on money, but honestly don't know. There's a very good chance, I will say that, but I can't say 100% at this moment. So I can guarantee if I'm appointed, I will be running.
Well, I hope so.
Yeah.
Governor Lee might have an issue with that.
Yeah, no, I'll be running. So.
Thank you, Chairman.
Thank you. Mr. Lancaster?
Well, I'm going to give Mr. McCarter a little stink eye because he stole all our good questions. I have no more questions for you, but thank you for your application.
All right, thank you.
Good morning. Can you hear me?
Yes.
I feel so low down. I have no questions, but thank you for your application.
All right, thank you.
And I don't have any questions either. Again, Mr. McCarter covered everything, I think.
Thanks.
Very thorough.
Morning, Mr. Terry.
Yes.
It appears from your application you have, shall we say, a specialized practice, do primarily title work, real estate work.
Yes.
Mr. McCarter asked you how many jury trials that you tried. How many trials have you had?
In the last few years, due to the nature of my work, I've not had a significant amount of trials. Before I switched into this area, I don't have a count, but I was in court frequently, usually once a week. I think I had the longest, at that time, I think I had the longest custody trial that had been heard in Chancery Court. It was 2.5 days, but I don't want to say a number because I might be way off, but I had several trials before switching into the banking and real estate matters.
And as I understand, obviously in this position, you need to be familiar certainly with the rules of evidence, the rules of civil and criminal procedure.
Yes.
Are you familiar with those as you stand here
To
today?
be quite honest with you, I'm not as up to speed on the rules of criminal procedure. So, but I can guarantee if I'm appointed that my nose will be stuck in that boat.
What's the percentage of the docket for that court for criminal cases?
I don't know the exact percentage, but I do not think it's that much because circuit court has criminal court jurisdiction. I mean, it has concurrent jurisdiction, but most criminal matters are heard in circuit court.
You think there would be somewhat of a learning curve for you if you stepped into that position?
Yes, yeah. But I don't think there's anything I can't do. I mean, if I'm going to do it, just like when I read that article in U.S. News and World Report, I said that's what I'm going to do. And if I'm going to seek this appointment, I get appointed, then I'm going to commit.
Sure. That's all I have. Thank you for your application.
Thank you.
Good morning, Mr. Terry. Just one question because Bert is always so thorough. If there is you're on the bench and there's a law or a statute that you just have a personal problem with, in your view, it should have never been passed. You don't think that it's in sync with what really happens in the real world, you know, which happens from the legislative bodies at times. How would you deal with that? Would you publicly seek a change in that law, or privately, or how would you deal with that?
Well, in the matter at hand, in the case at hand, if that was before me, I would be applying the law to the facts, whether I liked it or not, because I'm always a firm believer you apply that law as it's written. You know, I've been on the losing end where I didn't like the statute, but that's the law, and if it was applied correctly, then so be it. That's the way it is. But I think if there's something that really irks me like that or bothers me, then maybe, you know, maybe I bring it to my legislators' attention and let them deal with it. That's in their hands. So.
Would you publicly do that, or just privately?
I don't think I would do it publicly, no.
Thank you very much.
Good morning. I don't have many questions, but I will say that one of my fellow high-powered Knoxville attorneys that I work with was highly complimentary of you and has done some title work with you and the lending practice with you. Our firm does mostly real estate, so I wasn't surprised that one of us had come in, contact with you. But he was very, he said you do your job well, and wanted me to at least mention that. And I did appreciate your application. I thought that you were very brief, in a good way, and very concise. And I think I appreciate judges that can get what they need to say in a short period of time, and I think that was a very positive thing. So thank you for your application.
All right, thank you.
I don't have any questions directed at you, except that you did an excellent job of reacting to my fellow commissioners' stink eye comments, and for that, I have to say you did a good job. I think that Chairman Koch will be asking you questions that I would, and I'm going to defer to him. No questions.
That may be offensive to
No, this is a no stink eye zone. I really appreciate your concern about ex parte communications, and I just wanted to follow up on that for a minute. I think all of us, that when we entered on the practice, a lot of stuff we learned from watching other lawyers do it right, other lawyers doing wrong. and I know in my example, in my case, that there were a number of judges, and again, I understand the difference between rural and urban practice. This happened to be in Shelbyville, which is far from urban. But there were some judges who, had no particular reason to do it, but just would reach out and say, I want to get to know you. If you're going to be here a while. And, it wasn't, they weren't mentors necessarily, it's just they took an interest. And, that does a lot for a young lawyer's self-confidence and things like that. And so I say that because I'm trying to figure out how you seem to be very hard and fast about ex parte communications, but I assume what you're talking about is in the context of a case?
Yes, in context of the case. I don't think that should ever happen, so.
But I wish I knew this bar better. I do know a number of folks.
I've never had that issue in this county.
Well,
I can assure you, it was like a steel door if you wanted to get to the judge. I think a lot of us that practice in this county knew the former Chancellor's secretary. She was, she kept a good door between you and the Chancellor, which, no, I've just had experiences in my career where, there was ex parte communication, and I just didn't think it was right, and then I've been asked to go back and have a discussion. I wouldn't do it, so.
Well, and again, I commend you for that because rules are there for a purpose. The point I was trying to make is that this county has a pretty collegial bar. You know each other pretty well, and I think again, my experience has been that it takes a bar association to raise a good young lawyer. And so what role would you see if you're wearing a black robe that you would play in that in helping assure that the levels of professionalism that you all pride yourself in get carried on, and that there can be some times where youthful exuberance is going to get somebody to step over the line, and they don't necessarily need stink eye, but they may need somebody to very quietly say, there's another way to do this.
I've experienced that when I was first starting out. I did something that, I shouldn't have done, but didn't know any better, honestly. And the judge did take me into chambers after the case was over, and then had a discussion with me about it, and said, talked me through it, and said, this is how you should respond in that situation. And I think I would do the same.
Well, that's good to hear. And I have one other question. I'm sure that every member of the Anderson County Bar are angels. It's a rebuttable presumption, perhaps, but there are some lawyers that tactically like to push judges' buttons. How far can we go? It may be tactical, it may be just a personality trait, but there are going to be people, were you to get this position, that are going to try to push some of your buttons. And we're all human. There's some things where it's going to get to a point where our little inside voice is going to say, I got to do something about this. How will you handle a situation like that if somebody's getting under your skin?
I think same way. I think you get through the case as professionally as possible and still treat them fairly, but then you have a discussion with them afterwards and see if you can't figure out what the issue is and try to resolve it. So.
And you're perhaps you're better self-control than I've been, but there have been occasions where I said, let's just take a recess for about 5 minutes.
Well, that I'm sure that could occur, yes.
Well, thank you very much. Your very candid answers, and we appreciate it a great deal.
Thank you.
Thank you. Mr. Hauser? I believe General Helper is going to begin our conversation.
Good morning. I appreciate your making the trip to Franklin last week and chatting with me and basically bringing me up to speed on workers' comp, which I had no idea about any of that, so thank you. And that's a compliment. I really had no concept, and Mr. Hauser had a great understanding and helped me an awful lot. You spoke during your opening remarks about your family a little bit. So let's start by sharing with the commission from the legal career aspect. Kind of just a summary of your legal career and how you got to where you are today and your application for this chancellor position.
Sure. Well, immediately after law school, I was hired by an attorney by the name of Dan Scott. He practices out of Sevier County, sort of a thriving general civil practice there. I called it a big firm experience with small firm responsibilities. And shortly after being formally admitted to the bar, he handed me a stack of files and said, get in General Sessions Court. And so I was sort of thrown into the frying pan pretty quickly. Spent a lot of time in court, mostly doing creditors' work and contractual things of that matter. Over time, I was given greater responsibility on some of our other matters. We had a number of different complex property and contractual disputes. We represented contractors throughout the county. And then I also did a good deal of domestic work, divorces, post-divorce child custody issues, those kinds of matters. And we also had a pretty thriving debtors consumer bankruptcy practice that I managed. So we spent a good deal of time down at federal court, U.S. Bankruptcy Court, for the first 2 years. After working for him for a couple years, I was approached by Mr. Mullenauer and invited to interview with him. And he, at the time, basically had an insurance defense firm. It's a sort of a unique practice in that we actually all work from a home office. So when we would do depositions at medical offices or at plaintiff's offices, meet with our clients at their place of business, but we represent several insurers and several self-insured manufacturers throughout East Tennessee, and so we were practicing from Kingsport to Chattanooga to McMinn and Monroe County fairly frequently, in Anderson County a good deal. Worked against Mr. Bobo quite a good bit in front of Judge Elledge. So that was essentially the next 6 years of my practice, a lot of trial experience. At the same time, I also had the opportunity to hang my own shingle, so to speak, in Fountain City, which is in North Knoxville. I intended to continue my own individual debtors bankruptcy practice. One of the credit unions I worked for followed me when I went out on my own, so to speak, and I continued to do foreclosures for them and other creditors' work across the state. And I hung a shingle. Actually, my sign said bankruptcy attorney, and next thing I knew, everybody was calling me asking for a divorce. So I did a healthy amount of divorce work too, and family-related matters. I really enjoyed that experience. I enjoyed helping folks out of tough situations. And at that point, I decided it would be, I would enjoy learning about the juvenile court process, so I accepted appointments in juvenile court in Knox County and also Blount County. And then I had, around 2012, I got more interested in the insurance business. I was interested to learn sort of the back end of the business. I had spent a good deal coaching adjusters on their insurance claims, particularly workers' comp claims, and I found that they were often overworked, and there was lots of turnover, and I was curious to know how that whole process worked. So I went to work for a claims service, a third-party administrator here in Oak Ridge, and was quickly given a lot of responsibility. And in that short period of time, I had an opportunity to direct our telehealth nurse program. It's actually over 6 nurses, and I was coaching adjusters in that role. I had my own heavy desk of claims in that role, and then through that process, we also went through a transition of our claim software and some of the other vendors that we were using, and really learned everything I needed to know when the Knox County opportunity arose. They decided that they wanted to take their program back in-house from a third-party administrator they were using. They were sort of in a scenario where everyone was dissatisfied with how that was operating in terms of how the employees were their claims were being treated, and so they brought me on to build it from the ground up, and pleased to say we were able to do that and be successful at it. My goal has always been to sort of do the right thing. That's my motto from a claims practice. I don't know how many of you are familiar with the insurance industry or how they might handle their claims. particularly on a work comp perspective, many adjusters are not given a lot of authority on how they manage or direct medical claims. So oftentimes, if you have an injury where they go see an occupational health physician and they show up, that physician recommends an MRI and a referral to orthopedic, these adjusters basically are beholden to their triage, and they'll send these folks to 12 weeks of physical therapy before they'll authorize the PT. And in my view, that just adds expense. It's not helpful to expediting their medical care. So we sort of take the approach, we're going to expedite that process and trust our doctors. And if there's a referral, we're not going to hold on to that. We're going to actually ask for the MRI order now, go ahead and get them to their doctor so they can show up in front of their physician with that disc in hand, ready to move forward in case surgery is needed. And I found doing the right thing actually saves money in the long run, and our employees are happier. They get better treatment, and it actually also helps us be good stewards of taxpayer dollars. So.
You've mentioned do the right thing, and in going through many of the letters that came in, recommendation letters, a lot of focus I noticed had to do with your integrity. So talk a little bit, I guess, about what your approach would be, sort of with that mantra in mind, do the right thing, if you were appointed to this chancellor position.
I think it's important to approach this role with a sense of humility and respect, and integrity starts with conveying respect to the parties involved and the other litigants. I like to think that in my experience with other attorneys, they'll know that I might be a tough opponent, but they're always going to know where I'm coming from, and they can trust what I tell them and trust what I say I'm going to do or not do. And so from my perspective, that's essentially what I try to do every day in practice, and that's the approach I'll take on the bench. Excuse me.
And we talked a little bit during the pre-interview about skills that you've learned or come to practice over your career, and those skills, how would they guide you if you were the chancellor? And again, we talked about being on time, some of those sorts of things. So talk to us a little bit about what you bring or would bring to the chancellor position based on your experiences.
Sure. Well, obviously I've got a wide variety of experience in a variety of different types of law. Most of them are handled in Chancery Court. I think, forgive me. I think that, excuse me, I'm trying to get over my nerves. I think that I have the demeanor. I have a calm, level-headed, common-sense approach to practicing law. I've often found that an amicable resolution is better for my clients than simply trying to duke it out and win. As far as and basically, I think my relationships will demonstrate that I'll be fair and impartial to the other parties. I've also, like I said, I had the opportunity to sort of be thrust into some new experiences fairly quickly. Thrust into court right out of graduating law school. Thrust into this opportunity to build that program from the ground up. And so I think I've developed a skill set where I'm able to kind of take a top-down approach, a big picture view of what's needed in terms of evaluating any backlogs that the docket might have. Take a big picture approach and evaluate whether there are particular cases that require priority in setting and getting to those and being efficient. Another thing that I prided myself on is something one of my other mentors have always mentioned. I'm always going to exercise thorough, consistent, conscientious preparation. So I'll be.
This will be sort of from the Burt McCarter School, from what he mentioned earlier.
Elite group.
Yeah. Any unwritten rules that you think, or any rules maybe that are already in writing that are particularly important to you if you were seated as the chancellor?
Hopefully there will be no unwritten rules. I'd like to be very transparent about what should occur in my courtroom. Our local rules, I've reviewed them. One thing that I've always appreciated in terms of handling daily operations in court when I'm traveling to other counties is a judge who will come in and be seated, review the docket for the day, and he will take announcements first, defaults next, evaluate what's remaining on the docket, how much time is involved for each one of those, and have a conversation with the lawyers and trying to order those. That's always been helpful for me when I travel 3 hours away and maybe have to get back to town in the same day, rather than simply sitting there, because I've been through this experience too, where a judge will simply pull the docket and start at number 1 and come up and might not even get to announce an agreement or a default till lunchtime. So my plan is to be efficient and respectful of the parties, hopefully give everyone the opportunity to be heard, feel like they've been heard, while also doing my best to resolve matters. There's a question about, are you going to take matters under advisement, right? Our litigants, particularly in family law, have a huge interest in getting a ruling that same day as best we can, so that they can move on with their lives and the next step of that process.
We talked some about technology and its place, I guess particularly in this sort of post-COVID era, and how that works. And I know one of the things you talked about was phone hearings. And so just speak to us a little bit about the role you think technology plays today, and I guess particularly as it would relate to running a chancery court.
Well, I think it's important to strike a balance between what works and then what starts interfering with what's going on with the courtroom. We have here the ability for our attorneys to log in to the wireless connection and broadcast exhibits onto the TV for the court and the parties. That's helpful. One thing that we experienced during COVID in my workers' comp practice, when we had settlements approvals, state law requires that any workers' compensation settlement be approved now by the Court of Workers' Compensation Claims. And the statute actually requires that the parties, including the employee, appear in person for those. And those rules were suspended under the emergency order during COVID. And all of those hearings essentially took place by telephone, which I found tremendously helpful, not only for my own self, but especially for our employees. We have approximately 14,000 employees all over Knox County. And so it's difficult for many of them to find their way downtown, park. You know, if you're working for the schools, they actually require you to take a full half day off of work, 4 hours leave to come down for a hearing like that. And so in my view, it's just a huge interruption. So in terms of actually conducting those phones or those settlements by phone, is extremely helpful to everyone. I've looked, and I don't know if there are any particular rules or statutes that would prohibit this, but I would sort of like to invite comment from the bar and the other judges about whether or not it's necessary to have parties appear for agreed divorces when we've had an opportunity to discuss with the lawyers the documents, everything's in order. Do we really need to have them come down if they prefer not to or have other things going on that day? Difficult for them to leave work. Let's conduct that matter by phone.
You talked about if you're appointed, obviously you would be seeking this position. But if you're not appointed, we also talked about what your future goals were. So speak with us a little bit about that plan.
Sure. If I'm not appointed, as I stand here today, my plan is to run. This is something that I've always aspired to. I felt a call to service throughout my life. I've attempted to serve my community, serve a church, serve my family. And I just can't think of a better way to serve professionally than on the judiciary. And of course, till now, timing hasn't really been appropriate. But if I'm selected, obviously I would run. If I'm not selected, obviously the governor's selection is going to carry a great deal of credibility. But what I like to say about Tennessee, we love to elect our leaders, and that includes our judiciary. So I would enjoy the opportunity to earn the trust and respect of my community and get out there, roll up my sleeves, and start helping people, and see if I could earn their trust and put my candidacy to a vote.
And this is a little bit of a personal question, but you spoke in your opening remarks about the impact your divorce had. What about that? And my understanding is that the chancellor would hear a great deal of the domestic relations. What about that, and not specific details, but what did you learn from that experience that you think would aid you if you were AAD as serving as a chancellor?
Well, it was my first experience being a party to litigation, so let me tell you that. So, obviously, without speaking to the grounds, it was interesting to sort of be beholden to the court schedule, to getting mediation scheduled, and sort of the timing that took. I gained a greater appreciation of what our litigants have to experience going through that process, and sort of had an opportunity to experience emotionally kind of what that's like in terms of trying to move on with life and have a resolution. And so my hope, and what I think that means to me, it makes me want to emphasize that we want an efficient docket. We want to get these cases scheduled. We want to move them forward as best we can, as quickly as the parties are willing to move forward.
And you've talked some about serving your community, and you mentioned just very briefly. Tell us again about your service to the community, whether it's through Cub Scouts, through your gospel singing groups, which I just loved when you talked about that. So share that with us.
Sure. So I come from a musical family. My dad will never admit it. He's going to start blushing here, but he's one of the best flat-picking guitar players you'll find in the state. So my mom plays auto harp, and I took up the banjo later in life. And one thing we enjoy doing is playing on we joke, we call it the nursing home circuit around town. They love us because we're free, and we think we sound okay. But we enjoy playing for these folks. We play gospel and old-time music. Many of these folks, our nursing home elders, many of them are starving for personal contact. So it's an opportunity to sit down with them, play some music, and sit next to them. They'll take your hand and share their whole life story. And honestly, it's more rewarding for us than it is them. But so that's one thing we do. Obviously, I've served with the Cub Scouts and assist at church on a variety of different things.
And I'll just share with my fellow commission members, having a mother who was in a nursing home in Western New York and seeing the effect that those music groups brought. I wanted the commission to know that you were doing that work. With that, I don't have any additional questions, but very much appreciate your application and your time with me. Thank you.
Thank you.
Mr. McCarter?
What's the watt of the day?
Excuse me?
The watt of the day?
Today is 23.2. We're in the open, and I'm not going to make it today. So if you don't know, the CrossFit annually, they have what they call it the CrossFit Open. It's about 6 to 8 weeks worth of workouts that are intense, to say the least.
I'm not a participant.
Okay. Well, it's dangerous to ask a person who does CrossFit about CrossFit because we don't shut up about it. So I'm going to try and be quiet about it.
You talked a little bit in your opening remarks about your children. Where are they? How old are they? And where are they now?
Well, my daughter's 18. Well, everybody's at school today. My daughter's 18. I split custody with all the kids, so she's on target, like I said, to graduate in Knoxville. She goes to school in Knoxville. One thing we did intentionally at the time was to make sure that we wanted to sort of get set up so that the kids didn't have to change schools if possible. So their mother lives in that area where the kids.
Where does she go to school?
Bearden High School. Yeah.
And tennis?
Tennis, yes.
Where's she going to college?
She's going to Smith College. So growing up, she's wanted to go live in the Northeast, and I guess she watched too much Gilmore Girls or something, but it stuck. And so she's decided she wanted to go up there and play, and she had offers from a number of different schools, and that was the best one. So.
Great. I've enjoyed your presentation. You seem like the kind of individual that I don't think I'd get snake eye from. So, I really have appreciated your presentation.
Depends on how late you show up.
I'm gonna call beforehand if I'm late.
Mr. Lancaster?
Yes, and thank you for your application. I do have one question. You strike me as a person that's given this a lot of thought, and you understand what the Chancery role is. What would be your biggest, what would be the thing that you'd have to focus on most to get up to speed? The least experience in the role that you'll have to take on?
You know, I don't know that my challenges would be particularly unique to the other candidates that we have. As far as getting up to speed, it's just a matter of getting in the courthouse and getting with Mr. Cousins, the clerk and master, and Judge Spitzer, and kind of seeing where we are. So as far as that's concerned, I don't view that as a particular challenge. I welcome it and would enjoy the opportunity just to get to work.
And I know that this is a unique judicial district in that you're all in this courtroom or courthouse, and you have one chancellor and one circuit court judge. Do you all, is there an opportunity to share? I've heard some discussion about docket backlog maybe. I assume that's going to be the kind of thing that happens in both courts. Are you in a position to be able to help circuit court, or is that even something that's done when it's necessary?
I know it's done when necessary, particularly if there's a recusal issue, and I'd be happy to talk with Judge Spitzer about whether he felt that was something that was necessary. I certainly would be able to help most on the civil side. It would be a bit of a learning curve on the criminal side, but again, we just get in that preparation mode and start learning, if that were a necessity.
Thank you. Thank you for your answers and your application. Thank you.
Good morning. I don't have any questions, but I have two comments. The first is when Commissioner Helper told us about you all being on the nursing home circuit, I thought what a beautiful blessing that is to those residents and those families. So thank you for what you're doing. And then for being honest, thank you for being honest about your nerves. This is a big deal, and you all are all very successful in your respective professions, and so to put yourself out here and to stand up before us, and it is nerve-wracking. So thank you. You did a great job.
Thank you.
Good morning.
Morning.
I see from your application that at some point you had a business interest in a cryotherapy facility.
Yeah.
As a frequent flyer of cryotherapy, I guess you'd say, how did that go for you?
Well, excuse me, that was actually an idea. We have an old college friend who is a physician, and my former spouse had heard about this, and it was something they were interested in. So they went to Atlanta to try it out, and we started doing some research. And at the time, it was sort of taking hold across the country as sort of, for those of you who don't know, whole body cryotherapy is sort of an accelerated ice bath, for lack of better words. You get into this chamber, and they introduce nitrogen, and it rapidly reduces the temperature of the air and drives your blood to the core of your body, and you step out really feeling like $1,000,000. The goal is to help with muscle fatigue and soreness. So it was something we got interested in. We had some other friends who wanted to go in on the partnership, and so we opened a business in the Bearden area in Knoxville. And it went fine for us for several years. We actually had another partner that had came in. We had a mobile unit, and so we had the good fortune of serving UT with that. We had baseball and basketball, and featured on ESPN a couple times. So that was fun. But ultimately, COVID, it was one of those things. It's a very close, interactive type service when you're providing it, and we just weren't able to continue it in a way that was fruitful for everyone, so we elected to close that business.
So you're not telling me the process doesn't work or anything, right?
Hey, you got to try it.
Oh, I have many times. As I understand, based upon your current position, you're not really in this court of the position which you seek and haven't been for some time?
Sure, yeah.
Are there any changes that you know that you would make in the procedure or the process in this court if you were chosen for this position?
Well, one thing I have learned in working in county government for almost 10 years is that the government will churn slowly, and oftentimes when you come into a new role like this, it's not helpful to insist on making unilateral changes quickly. I've found it's often takes time to earn the trust of the folks that you work with, and so it's important to take input from those around you, the clerk and master, the judge, the bar, to discuss whether they feel like there's any changes that might be required, and then move forward incrementally in that way, would be my approach.
Would there be a learning curve for you with regard to criminal cases?
Yeah, there would be. There would be. I mean, I've studied in law school, obviously, but I stepped foot in a criminal courtroom one time on behalf of an old friend, and had the case dismissed, thankfully. And so that would be a learning curve, but not something unwelcome. I'd be happy to learn as needed.
How about probate work, conservatorships?
Yeah, I've done a fair amount of probate work. I've probated several estates over the years, and I've litigated those, particularly at Dan Scott's office. We had a number of different types of issues, arguing over property distributions and those kinds of things. So yes, I've done a fair amount of that.
That's all I have. Thank you for your application.
Thank you.
Thank you, Mr. Chairman, and point of personal privilege, if I could. We recognize an old friend of mine, Judge Tom Wright, who's one of the senior judges in East Tennessee, and I've known him for years, and it's good to see you, Judge Wright. Good to have you with us. Mr. Hauser,
When you said that, I'll take my leave of you all. I just wanted to say how much I appreciate you all in doing this work, and the reason I'm here is because of this and Judge Spitzer, who was an ADA, so Judge Ash and I are almost fixtures in Anderson County at this point, doing Chancery and criminal work. And I had a criminal case this morning, and I could get back to Green County. But thank you all so much for this work. I appreciate it.
Well, Your Honor, thank you for coming.
thanks, Judge. Mr. Hauser, good morning. Appreciate your application. Just one question. I was a county mayor for 16 years. You've been involved in the rough and tumble at the high levels of Knox County government as a senior law director. Politics, just all around you, probably every day. You have to deal with what the law is, what your recommendations are, but there's a political opinion also, as you know. So let me ask you, as a chancellor, you are elected. Is a judge a politician?
Right. Well, judges do have to be elected, right? But obviously the judiciary is set apart in that manner, and our role is to be the third part of government and faithfully and dutifully interpret the laws as they are enacted in the context of those cases that are before us. And it's the governor or the mayor's responsibility to execute those, and our role to interpret those. So we have to be careful about how we convey ourselves to the public. We don't want to convey any particular political leanings. We have to be impartial. We have to not give any kind of appearance of impropriety or favor to any party. So to that extent, we're politicians in that we have to be elected, yes. But no, we have our own role. We're not going to get out and campaign in a negative way. Rules prohibit it.
As a sitting chancellor, you feel comfortable that you can navigate being on the bench at the same time that you're on the ballot and having to conduct a campaign?
Yes. I've never actually been a part of a campaign before, other than I have helped friends. So I certainly will do my best to enlist some help in understanding that process, making sure all the financial disclosures are filed on time, that sort of thing. But yeah, I'm prepared to handle that.
Okay. Thank you. Thank you, Mr. Chairman. Thank you.
Thank you, Mr. Chairman. Mr. Hauser, thanks for joining us here today. As a living in Knox County, I appreciate the work you did to save our taxpayer money. I saw in your application that one thing that spoke to me is that you have a penchant for taking the initiative when you see an issue, and especially with the workers' compensation, and not only helping teachers get more benefits, but also saving taxpayer money, I think that's a great thing. I think, did I steal that from Tom? Probably.
No, I'm still trying to figure out, it would be a raise for him.
And I do appreciate knowing a lot of the members of the Knoxville Bar and people in your office, and you had so many recommendations from your office and especially from your boss. Most of what I was going to ask has been said, but the one thing I did mention I noticed of your application you brought up in your first remarks is that you're an English guy, and my note was well written, so I think that I can corroborate that. But the one thing you did lose me on is that you enjoyed doing divorce work. Does that also apply to enjoying workers' compensation work? That was a joke.
The fact that I enjoy it?
Yeah. But do you, as a question, do you enjoy what you do right now?
Mike always joked that when he was working for the law firm, the work comp work is the undistinguished work that they give to the partners they don't enjoy so much. No, but in all fairness, I've enjoyed it. I've enjoyed getting to learn the process. It's been more rewarding to sort of convert from a role of insurance defense attorney. I still serve in that role for the county, but being self-insured, we have a greater freedom to do what's right by our injured workers. The county has an interest in that, and if we can save money at the same time and do the right thing, that's the goal.
Great. Thank you for your application.
Thank you.
Mr. Hauser, I'm not going to ask any particular question as to you, but actually I'm addressing this to all the applicants. If you all have the name of a good ophthalmologist to help Bert with his stink eye, I would appreciate you giving him that information today. And if there are some really good ones over here in Anderson County, I'm sure he would enjoy making that drive. Other than that, I think you calmed down and you put forth a good effort and a good presentation today, and I do not have any questions at this point. Mr. Chairman, I yield back to you.
Thank you.
Thank you.
Mr. Hauser, I'm going to scrupulously avoid asking you to critique anything I did in the workers' comp area. You can get me out in the hall later if you wish. But it is very impressive what you've done with the workers' comp program in Knoxville. I'm curious, and of course you would not do this probably if you were on the bench, but about 10 or 12 years ago there was a sea change in how Tennessee handled workers' comp cases. You have some general comments about the ways it succeeded and the ways it hasn't? I mean, how do you think it's going?
Yeah. One thing I found, at least in my professional perspective, when I was working for Knox County, we went through a short period of time where we had claims that were approved under the old standard of proof, and then shortly after the sea change there were similar claims amongst our employees that required a bit more scrutiny from a medical perspective, and after scrutiny, those types of claims did not stand up to the test for approval, and certainly that caused some discord in different departments. Those individuals felt like they were being treated unfairly simply because of the law change, but sort of made every effort at the time to talk to those individuals and recommend that they seek counsel. Many of them did, and determine whether that's something they want to pursue.
You made a comment in answer to a question earlier in terms of efficiency, and I think I can quote it. You said that you would want to move as quickly as the parties are willing to move forward. And not all lawyers necessarily want to close their files. So I'm just curious, you basically control the pace of how things are going. Is there going to be some expectation that at some point these things need to end, and how would you communicate that?
Sure. Well, I sort of mentioned that in the context of thinking about divorce cases. Occasionally
some of those need to get closed.
Occasionally the parties, they do want to take a break because maybe they're exploring reconciliation and they're not interested in moving forward so quickly. But for those cases that are kind of hanging out there like they do, in state court sometimes. My goal would to review all of those, set status conferences, maybe issue show cause orders if necessary, perhaps docket call. Those would be the tools I think I'm equipped to be able to use.
Well, when you were learning to play the banjo, did they make you practice in the barn, or did they let you stay in the house?
You know, that was always funny. I had my own office in my basement, so I spent most of my time practicing in between phone calls and emails, and then I would practice with my kids when they were in the bath when they were little, and they stopped complaining about it eventually. I guess I got good enough to where it didn't hurt their ears so much. So.
There's a NSL graduate who toured with Ralph Stanley for years and then started his own band. His name's Charlie Sizemore. And Charlie's last #1 hit in 2011 was a song called May There Be No Lawyers in Heaven. Do you happen to have that in your repertoire?
I do not, but what I do have hanging on my wall, there's a great comic that somebody put out years ago, and it's a picture of a dad standing behind his son, and he's on a stool with the banjo, and the caption is, "Son, being a lawyer is an honorable profession, but you need something to fall back on something. So practice your banjo."
There you go. Thank you so much.
All right, thank you.
Appreciate you.
Appreciate it.
Mr. Chairman, on behalf of the more senior members of the commission, can we take a short break?
Should we put it to a vote, or we'll do it by acclamation? We will.
I think we'll leave it at that kind of time.
15-minute break.
He's getting in practice later.
Thank you all for being so punctual. Mr. Forrester, if we're ready. I believe that Commissioner Perky is going to begin
Thank you,
the
Mr. Chairman.
conversation.
Very good.
Let me pull my notes up here.
Took your coat off. You're getting serious on it now.
Good morning, Mr. Forrester.
Good morning, Mr. Perky.
Thank you for the interview, and we had a good discussion, and I appreciate your application today. So if you would, for the commission, just tell us a little bit about how you got to where you are today, since high school.
Since high school, well, I'd like to say there's nothing extremely remarkable or anything about my life story. I graduated from Campbell County High School, just right up the road from here. Then I went to ETSU, and while I was there, actually, I started out, switched majors a couple of times as a freshman, went from biology, which was horrible, to accounting, and just hated it. Thought it was awfully boring. And while I was there, took criminal justice, and actually had a professor there that was a lawyer that taught criminal law, and just fell in love with it. And from there, majored in criminal justice, and took the LSAT. And then when I got to the end of my 4 years, I was sort of burned out of college and decided and took a break for about 1.5 years, and then realized that I needed to go back to school. And so from there, went to ETSU for, after graduating from ETSU, then went to law school, where I graduated in 2005, and then returned back to Anderson County. And shortly after passing the bar and being sworn in, as I was telling the committee in my introduction, started working at Ridner and Ridner, and started handling divorce and all the fun cases, custody cases, terminations, adoptions, conservatorships, and criminal law, juvenile matters, and been doing it ever since. Probably if you had asked me what I was going to do when I graduated, it would have been, I would have said, I want to be a prosecutor. To me, I thought that was a grand idea. You have the discretion to prosecute, and I thought would be probably my first pick. But of course, coming out of law school, you fall into private practice, and sometimes that's the sort of, maybe, I don't want to say fate, but just sort of how things have happened for me, and I've been here in this county ever since.
Mr. Forrester, I know that a chancellor doesn't deal with this much at all, but since Tennessee is a death penalty state, I'm always interested in judicial candidates and how they feel about the death penalty. I'm not looking for a certain answer. It's just a kind of a standard question that I ask. And what are your thoughts on the state's death penalty?
I think overall, I would say I'm in favor of the death penalty. I would also state too, sort of my thoughts on it as I've gotten older. You have a little bit more reservation about it than I used to. Maybe I've watched one too many documentaries about someone occasionally being falsely convicted or something, which is, I think, very rare. And the process is lengthy. There's issues with it overall, but even though I would think as chancellor I may never ever have an occasion to hear that type of case, I would certainly follow whatever the legislature has in place for us in terms of the law. I don't have qualms in and of itself about the death penalty. I grew up here in Tennessee, and from a very early age heard the old adage, an eye for an eye and a tooth for a tooth, and so I support it overall.
Thank you. If you're on the bench and you're the chancellor and an attorney comes in late, that attorney hadn't called, you hadn't received any notice from the clerk, how would you handle situations like that?
Well, I think if I'm on the bench, first it would probably depend on if I knew the attorney. If it was someone that routinely came into my court that I knew this was not a normal thing, I would say nothing. Every one of us are human, and on occasion, sometimes you just have a bad morning. The other thing is if I'm handling other matters on the docket, and likewise it didn't cause a disruption or a delay, maybe again, not say anything. If it became where it was an issue with a particular individual, or maybe they were routinely late, I still don't think I would address it in court necessarily. I think maybe at some point call them up to the bar, or maybe have them come into chambers after the fact and just say, hey, it's important that you're here on time, and maybe just have a discussion with them. I would think my opinion would be dressing them down in open court is kind of, I don't want to think that's where you go to first. I think there's already, as attorneys and judges, I think we have to be weary about the public perception of our system as a whole. And I feel that if I'm out there dressing down attorneys for some gentleman that maybe was 10 minutes late on a rare occasion, the public sees that. And so I think if it's something that can be corrected simply by maybe a quick conversation with the gentleman or the lady, whoever it may be, I think that would be my approach.
Referencing something that Bert mentioned earlier, you're the chancellor on the bench, and you started a trial. Shortly into that trial, one of the attorneys, it's obvious to you that they're not prepared. They're a little bit disheveled. They're making easy mistakes. How would you handle that once you're into the proceeding?
I think it may depend. I've routinely have had hearings with attorneys and been involved in hearings where I've seen attorneys miss easy objections. That may in and of itself could be maybe they don't want to object. If I could tell the attorney's maybe disheveled and just flustered, maybe just take a brief recess and maybe call them to the bench and say, hey, I'm going to take a 10-minute break. You know, take a breath. Everything's fine. Get yourself in order, and we'll continue. If it's more serious to such a degree that maybe I feel someone is impaired or there is something very serious going on, that might even be a case of more than called up to the bench. It might be that I need to see the attorneys in chambers, find out what's going on, and if it is set to such a degree where it's just very concerning, it might be that we have to continue the case. I wouldn't want to do that, and if it's maybe the case, like there was a question about a new attorney where sometimes maybe you can't try the case for them, but if you can perhaps maybe hold their hand, so to speak, a little and kind of get them through, maybe that can be the way that's handled. But I would imagine just it would depend on the degree of what I was seeing, I guess is my answer, and depending on the degree would be my response.
Many times in the media, we hear people say, I've been the victim of an injustice. We hear that term thrown around probably too loosely. What would that mean to you? What does the word injustice mean to you?
I think, and I've heard it said myself outside of the courtrooms here, when people come out, they're dissatisfied with the result. In that sense, I would have to really know the facts of the case before myself would make a determination. To me, an injustice would be actually some misapplication or gross misapplication, so to speak, of the law. But generally, when I hear that, usually it comes from people sometimes just don't have a full understanding of the law. One example I could give would be on a criminal matter. I've had cases where you've seen victims that are just horribly upset over the sentence a defendant receives. And they don't understand sometimes the defendant has only committed an offense that has a specific range that may be probatable or maybe only have very limited jail time. And when it involves their loved one or someone, of course they expect this person, and maybe rightfully so, should really be in jail for a long time depending on the case. And so when I hear that, I always take it with a grain of salt unless I really know what happened in the case, because at least with my experience here in this county, I don't know that I could name an occasion where I've walked out of a courtroom here in front of any of our sitting judges or in front of Chancellor Cantrell or Chancellor Lantrip where I felt there was a gross misjustice or anything of that nature. And so we do hear that, but I think that comes mainly from the public's, I would say, false expectations of what to expect in a courtroom. Rarely ever do we have two divorce clients that come out of a divorce trial happy. Usually they are both unhappy, which means the court probably made a correct ruling, and neither side, we ended up in the middle of what both sides probably wanted to have happen.
Let me ask you the same question that I asked Mr. Hauser earlier. The chancellor's elected, obviously, every 8 years. You'll have to run a campaign
Yes.
if you want to retain the seat, if you're appointed by the governor. So how will you separate that from the fact that you're a sitting judge. And is a judge a politician by definition?
I think a judge outside of the courtroom, just the nature of our political system, has to be a politician. I think we have, you're pretty much either going to run, if you expect to be elected, either as a Republican or a Democrat. And so, in a sense, yes, we have to be politicians, but when you're on the bench and in the courtroom, it does not matter who's before you in terms of their race, creed, their beliefs. You have to treat every person in that courtroom the same. It does not matter what their beliefs are, unless it's just something pertinent to the case, but generally, all of that is set aside outside the courtroom. And then, of course, we have the judicial canons in place as well, which puts out guidelines for what you as a member of the judiciary can and can't do while you're campaigning. And of course, there are some limitations to judges and things to help minimize the political perception of the judge in the community.
Do you have a big ego?
I would like to think I do not. I would like to think I'm the opposite. And just to be candid, I have been more stressed out about introducing myself to the committee this morning than if you'd have told me I had to do a week-long jury trial and do an opening in 30 minutes, because I have a hard time standing up here and talking about myself. I've always been raised from a young age by my father is, you do not have a big ego. You remain humble. And I've always tried to be that way. So I have more trouble talking about myself. I would do much better if you said introduce an applicant. I would get up here and could probably sing their praises better than my own.
Would you have any trouble declaring a conflict if you had one?
No. I think if one arises during a case or one is brought to your attention, I think you absolutely disclose it immediately to the parties and to the attorneys so it can be dealt with. I don't think there's any question if you see one that has to be done.
I'm almost finished here. Tell me your thoughts about the three branches of government. And what I'm looking for in particular there is if there's a statute you don't agree with, or that just kind of, you just think it's not practical. The legislative body missed it. How would you deal with that, and how do you feel about the relationship between the three branches of government?
Well, I think, from an early age we learned about our three branches, and they're set up that way for a reason. We have the executive branch to enforce the laws, the legislative branch writes the laws, and then the judicial branch more or less applies the law to the matters before it. If I disagreed with a law or statute, that is not my job as a trial court judge to do that. My job is to apply the law. If there's something wrong and it needs to be addressed, in my courtroom would not necessarily be the place for that to happen. Their job is to apply the law to the cases before us, even if we disagree with it.
You have any complaints filed against you?
Never had a formal complaint. I've been practicing for 17 years, and so in complete candidacy, on occasion have I had, when you're dealing with the public for 17 and a half years, I've had an occasional letter by someone written in that, of course, the bar took no action or basically said there's nothing to this, but I've never had a formal complaint or any disciplinary action of any kind.
All right. Thank you, Mr. Forrester. Thank you, Mr. Chairman.
Thank you. Mr. Wallace?
In keeping with what I've been doing, I'm not going to direct any particular questions to you. And for that reason, I'm just going to pass it on to my fellow commissioner.
Have we hurt your feelings or something?
I still have an applicant yet that I can just stretch it out a little bit later that you all will get to meet.
We'll be here at 5 o'clock.
I believe he'd prefer just to give stink eye. Well, thank you again for your application. I wanted to follow up on one of what Commissioner Perky's last question. I did notice that in our report from the AOC that there had been 3 complaints filed as early as 2021 and 2027 or 2017, excuse me, and 2016. But I didn't see those listed in your application. I just want to give you an opportunity to explain those to us.
Oh, absolutely, and if I did, I think when I read the application, I think I took it as a formal complaint from the board. I'm very aware that everyone here on this committee can absolutely get our entire record, and so by no means would I not disclose something like that, and so that would candidly be entirely on me, just probably misunderstanding what was meant on the application. And that's what I said. There occasionally have been letters, and in fact, the last one I think referring to was a young lady that wrote about 7 letters to the board, and the basis coming of which she just wanted some of her fee returned. And then I sent in an example of the contested billing to that, and turned out we had worked way well in excess of what she had sent in. And so I would by no means, like I said, do that intentionally. And I actually kind of pondered that after I'd submitted it and thought maybe I've misread this question, because I'm well aware everyone here can fully get a record from the Board of Professional Responsibility.
And you're not alone in having board complaints. I think the majority of the applicants did have those, but I just wanted to give you an opportunity to explain that to them.
And absolutely, and I'm very thankful you did ask, because like I said, after it was submitted, I still have that back and forth in my mind that maybe I had misunderstood or misanswered that. But absolutely, I've had occasional letters over the years. Back when I first started practicing, where I do criminal defense, there was a thing going on at the jail where every spring they would just start writing letters on their attorneys, and we would talk about it here because we all got them. And so it was not uncommon, but I thought the major thing was looking for is if you'd ever had a formal disciplinary or complaint, which I have not.
In looking at your application, it looks like a majority of your practice is domestic relations. Coming from a transactional real estate background, can you give us some examples of real estate transactional work, probate work that you've done recently, or that you have that experience since it would be part of this role?
Absolutely, and I'll be candid, that is not by far as much of my practice as the domestic relations and criminal work. I'm currently involved in a partition action right now, actually in downtown Knoxville and Kingston Pike, which
with my firm.
Yes, and so it's about $6 or $7 million, give or take, of property.
Heard about that this week. So that's not a conflict. I didn't know that until just now.
And so I'm involved in that. Likewise, I'm in the middle of an estate case right now that I have involving Ann Mostoller and Phil Cry. I'm trying not to get too specific, but we do handle some here and there. But I'll be candid, I really do not handle as many real estate matters just because I just never really, occasionally I will do something like that, but my practice was so busy with what I do that was some of the things I really just sort of pared away from my practice just because I really felt I didn't have as much time. But I do occasionally handle them, but I won't sit here and act like I do lots and lots of them. I really do not.
I guess as a follow-up, do you feel confident that, if presented with a case, in those arenas that you may not practice as frequently, do you feel comfortable making a ruling, or at least being, preparing ahead of time?
Yes, I do, and I think if one of the things I think would be important, of course, if you're a chancellor, is you're aware, you should be aware of what's coming up in your docket, what's set for you, and you should be prepared beforehand before you ever step foot on the bench. And so if there's a matter coming up, say a partition action or something, or some other interesting matter, I would hope I would be rather well versed and researched on it and be prepared to rule on the case and hear the proof when it came before me. And so yes, I do think I could do that.
Well, I have no further questions, but I do have one anecdote. This has not happened in my my very fledgling practice in this body, but I make it a point to call references on applications, and I did call a reference that was on a different applicant's application, and the lady who answered the phone recommended you, and then the person who I ended up speaking to, who was listed as a reference, also recommended you, which I thought was interesting to say the least. But I've heard a lot of good things from people in the local bar that have contacted me, and I've heard received a lot of recommendations in your favor, whether they sought me or I inexplicably sought them out on accident.
Oh, well, I'm very glad to hear that. Thank you.
So thanks. Thank you for your application.
Well, thank you.
Good morning, Mr. Forrester. To follow up on something Mr. Marcus had asked about, you indicate in your application that you have been involved in over 1,000 custody and divorce cases.
I would say that's pretty accurate.
My sympathies to you there.
We always have the best stories, I find.
And you also indicated when he asked you that there had been no formal BPR complaints, which makes you a legal unicorn, I would say.
Yes, I don't disagree, and maybe it's just fortunate in some ways. I think as a human, as an attorney, at some point, I'm sure I've made a mistake on something. And
Well, but to follow up on what Mr. Waters asked you, the BPR is showing that there were 3 complaints against you, and I know we talked about this on the commission before. The way their system works is if they dismiss a complaint without allowing you to respond or seeing the need for you to respond, you never get notified. So was that the situation that occurred here?
I can only think of one recently that I can recall, and again, it was the one I was referring to with him where I was in an extensive amount of communication back and forth on that one in particular. And so I can't recall offhand the others, so I'm thinking maybe that was the case, because I don't recall, you always get I call it the small heart attack when you go to the mailbox and you get the letter from the board. You're like, oh no, what is this? And I do not recall having one in quite some time. And so,
like I said, you may have never been notified, which I'm absolutely amazed that that's the procedure, because I can't believe somebody could file a complaint against you, whether it's frivolous or not, but you never find out about it.
And I think the one I was referring to, again, with Mr. Waters was even older than I think that. I think the more I think about it, that was maybe a few years ago. And so I would imagine as well, because if they'd sent me something to respond to, if you do not respond to it, and I think it's 10 days or 7 days, you get a follow-up letter, and if you don't respond to that, you get the horrible, we're going to suspend your license sort of response. And so, I honestly, maybe that's the case. I can't think of it offhand.
You also mentioned what I perceive to be an inherent unfairness in the application of the child support guidelines. And I understand that you're not seeking a position as a legislator, but simply a trial judge. But how would you change that?
If I were going to change it, it would be only through the legislature. You certainly would not do it from the bench. I think regardless of my personal, and I don't think that's always the case. I think the majority of the time, the guidelines do what they're supposed to do. I think there is some occasion where we see in divorces where you have a 2-household income. When they split, each party is now at an individual household income. One individual starts working 2 jobs or starts working overtime to help make ends meet. Also, as a side effect of that, he's not seeing his children as much. And then the next thing you know, they go to child support court and they get hit because they are not seeing their children and they have overtime, and the state, by the Tennessee child support guidelines, takes all the income, doesn't matter if it's overtime or not, and uses that as the gross monthly income. And so sometimes I feel instances like that can be unfair to an individual because creates sort of a snowball effect. Then he has to continue to keep working all the time, extra hard, to pay the bills and to pay the higher child support amount. But with that being said, now I would still, whatever was before me in court, you still follow the guidelines and the law. And so even though it may have that side effect, maybe it would be something where something is done through the legislature, but definitely not in the courtroom.
That's all I have. I appreciate your application.
Thank you.
Thank you. Taylor?
Thank you for your application. I noticed that you, I believe, still continue to do some criminal defense work.
Yes, ma'am, I do.
How, working with Judge Spitzer as the chancellor, I would anticipate at times there would have to be some perhaps interchange because of recusals, whatever. So share with us how you think that experience maybe sets you apart from some of the other applicants.
I think it helps. When they established their courts here in 1974, these courts are actually both circuit courts, and they designated the Chancery Court as the Chancery and the circuit handles the criminal, but they have the same jurisdiction 100%. It actually says in the statute that created it that they both have the authority and that the presiding judge can actually govern the caseload, so to speak, and divide it out among the courts as needed to help. It's not really ever happened since I've been here. Circuit has always kept them, but one of the things especially that we've seen where Judge Spitzer just went through this, he also has conflict cases that come through where he was the DA for that particular defendant. And so it would enable us, essentially, the matter can just literally come across the hall and I can handle it. And likewise, hopefully, if I will have conflict cases as well, he would be able to handle my conflict cases. So I think it would work out to both of our benefit. And the other thing that could happen the Anderson County, there was a question about statistics. The Anderson County Circuit Court here is 80% criminal in nature by its volume. If there was ever a time, and I don't know, Judge Spitzer does a very good job, but if there was ever a time he needed help with the caseload, it would be something where maybe misdemeanors come over to my court if I was the chancellor, or maybe just even VOPs, things that would really unclog the docket that you have hearings on. And so it would give us the opportunity to really, I think, streamline both courts if it was needed, as far as maybe easing up the caseload.
And if I understand correctly, much of your practice is here in Anderson County, is that correct?
Yes, ma'am.
But you moved here last September.
That's correct.
So talk to us a little bit about that dynamic, I guess.
Absolutely. As I've stated, I'm originally from Campbell County. And from day one, even when I first passed the bar, I'd actually lived in Oak Ridge for a brief period of time and then moved to Campbell County. And the reason it sort of ended up that way was I moved next door to the family home. My parents lived right down the road, and when a house became available, and I was going through, I don't want to get into all the old issues, but I was going through a divorce 15 years ago. And so when I moved from Oak Ridge, I ended up moving there, and my thoughts were this is temporary. I was going to move back. Temporary turned into years, just by virtue of you get into your life habits and do things. But really, but for living about 9.5, I think, miles across the line, my practice in life has always been here in the Anderson County. As I was telling the committee, my children have always went to school here in Anderson from day one. My little girl, she's not little anymore, I went to Mother's Day out here before she was even in school. She participated in a pageant just not too long ago, and it was to raise money for the Clinton High School. My son has always went through Oak Ridge. He's a junior. Both of my children got their Krav Maga junior black belts at National Martial Arts, which is in Oak Ridge. All of our friends and associations are here. And so, but for the fact that we did that and we finally decided to make the move, and we found that we needed a bigger home and moved out to Andersonville, and we now go to church out there at First Baptist Church, and my kids love it. My son, who's mobile, now that he's 17, routinely goes on his own on Sunday nights and Wednesdays, which, you know, I couldn't ask for a better teenager. It scares me sometimes how good he is. When I was his age, I was doing things that, you know, teenagers do, and he's a very good young man. And so, but for that, and the fact we were just commuting back and forth, we've always been here. Any activities we're involved in, any sponsorships, we have always do. It's here in Anderson County, and so this is really where our home is. My wife's from Clinton. She graduated from Anderson County as well. Her family's still here in Clinton. And so all of our relationships, if I were to call an individual right now or any friends and say, hey, let's go have dinner tonight, they live here in Anderson County. I mean, this is just where really, I feel like I'm part of this community. My office, and that's why I said I walked over here this morning. You know, I'm 1 block away. I walk over here every day for court. There are days I'm in this courthouse. I'm in here 3 to 5 days a week. Some mornings I handle multiple matters, and I'm going back and forth between courts, and Judge Spitzer's gracious enough, especially on Mondays when Chancery is going in criminal, he will let me go back and forth and kind of help me with that because he knows I'm busy in those courts. And so I feel like I'm a part of the community. I feel like me and my office are sort of a fixture here on Main Street. We've been there since 2009.
Thank you. I have no further questions.
Mr. Chairman, I don't have any questions, but thank you for going through this process.
Thank you, Ms. Morris.
I only have one question. Thank you for your application, but you are a solo at this point?
Yes, sir.
So if you take this bench, you're giving up your private practice.
Oh no, it's definitely been something that we've thought a lot about, and it'll be could be a very trying time, so to speak, because one, I'm going to have to give up my private practice. You may also be having to campaign and then also take the bench, and so I equate it to about 4 jobs in one, maybe 3 jobs. So it's definitely something we had to put a lot of serious consideration into.
In your opening statement, you made the comment that you could hit the ground running. So that's what made that question come to mind, that you're solo. This bench, this docket is backlog, and as you mentioned. So what would your priorities be?
Well, I think obviously first and foremost would be the bench. I think we have to get in and get cases moving. And the reality of it is this courthouse is open technically 8:30 to 4:30, maybe 5 o'clock. And so it'll be a lot of nights and weekends. I'm gonna have to go and sort out my practice as I can between days, and maybe days where there's not as much going on in the courtroom, and get things sorted out. I think I was also referring to the fact I felt like because I've spent so much time in that courtroom and handled the number of cases that I have a really good understanding of this court, and that I think I could come in and get things moving rather quickly.
Is there anything in particular that you would institute? I know we've had a lot of conversation, but you kind of get the ground, and you kind of see what's there. But you've been in this court enough to. Do you have anything in particular you think I'd love to get that started?
As far as a change, or as far as
a change?
The only thing I could think offhand that I would see, maybe slight differences in how Chancellor Cantrell called the docket up. She would call, Chancellor Lantrip did it they almost did it the same way. Chancellor Cantrell would always take the adoptions first, which I think is a great idea. Then from there, she had got into the habit of she would call things in a certain order, but she would not always ask attorneys for, let them take brief matters. That's really probably the only gripe it's not even a gripe. Maybe the only thing I would say that I might do a little differently would be to give the private bar a chance to call up, because I know how it is if you need to get out of there and you have a 5-minute announcement. And so other than that, really and truthfully, Chancellor Lantrip was doing that, running that court until he retired. And then after that, Chancellor Cantrell stepped in, and obviously those were two very smart people, and that court runs really pretty well overall. So I would think it would be a mistake to go in there and make a drastic change. So that's why I say, when I say my proverbial gripe would be how the order she called things, that's a very minor. And so overall, if you said you go in there today and you change nothing, I would think the court would still run rather well. I just sort of have a slight perception about the private bar and maybe getting some people out of there quicker.
Thank you, and thank you for your application.
Thank you.
What's your take on alternative sentencing? You do a fair amount of criminal work, and you might hear some criminal type cases. What's your take on that?
I think alternative sentencing is not necessarily a bad thing. I think in times it can be a very good thing. We have a drug court program here in Anderson Criminal, and actually I think I've started to put it in my application, and maybe I did. I can't recall if I cut it out or not for brevity. But I had a young lady that I tell everyone the story to that we put in there that at one point had a horrible drug problem. Her family had disowned her. I'm trying to go quick. Lost custody of her child. At one point while on probation was going to commit suicide. And so they violated her. We put her into drug court in front of Judge Elledge, and Judge Elledge knows probably who I'm talking about. She graduated, and I came and spoke for her on graduation, and she actually worked her way up. She was working at drive-thru in the Wendy's, and we would go through and see her at night while she was in drug court and say hi to her. And she graduated, went all the way through, and I think started working a corporate job at Wendy's, and then I think went out to work for herself, maybe as a beautician. But it was just a wonderful story. I mean, you couldn't ask for a better story of someone who turned their life around. She got custody of her child back. Her family, most of them, had made amends with her. I mean, it was like the Cinderella story of something like that. So I'm in favor of it. I'm not always in favor of it. I don't think it's for everyone, but certainly for that young lady, I will never forget. And she would still, from time to time, come by the office just to say hello. So I would say I'm a fan of that sort of thing, just for those instances.
I really appreciated that part of it is in the application.
Okay, good.
I appreciated that. That's why I asked the question, because I'm a huge proponent of alternative sentencing and rehabilitation and trying to help people and really kind of peeling the layers off and finding out what their real issue is. And I think there may be some value. I didn't know if there was something of that nature here in this county that have.
Oh, absolutely. We have a drug court here in criminal court that was started by Judge Elledge. He really spearheaded it. And it's right now, it's sort of unique program. They only take a handful of applicants, and I believe it's 5 at the moment. I don't recall the exact number, but they take a handful, and it's very intensive. I've not put an individual in it in some time, but they come weekly. They weekly get drug tested. If you graduate that program, you have done well. It's a very tough program, but it's a very good program.
A couple other things. It looks like you just, I say recently, within the last 3 or 4 years, have become a mediator, Rule 31 mediator.
Yes, sir.
And you've done over 100. Is that primarily in this judicial district, or where do you primarily operate and do your mediations out of?
I do a fair amount in this county. I do a lesser amount, but still a fair amount in Knox County. And then as well, I go up quite a bit because there's a shortage of mediators. There's up to Campbell in that district as well somewhat. A lot of the attorneys up there will use me. There's just, as you go further up the interstate, there's a shortage. There's just not any, and so there's Bill Pratt, who's a retired attorney, does a fair amount, but I would say still the majority are probably in the county by a pretty good amount.
Do most of the domestic bar here use you as a mediator?
I would say that almost all of them, probably all of them do, by a fair amount.
What I find really kind of unique about this is I understand that your chancellor basically ran for re-election, got elected, and decides to pack up ship and move to like Australia.
I think that's correct.
I want to see how you're going to work out.
I'm not coming to Anderson County. She may be coming back unemployed. Would you have run for that position had you? Let's say she said, "Look, I'm gonna retire, and this is it. I'm gonna step aside." Would you have run for this position? And let's forget about the residence requirement. It's not a trick question. I'm just interested to know whether you would have run for this position last year
Against Chancellor Cantrell.
or if it was an open seat.
If it was an open seat, yes, I think I would have considered that. Now, at the time, obviously, I don't know what my circumstances would have been, but yes, I think then I would have considered it. If the scenarios changed and Chancellor Cantrell did not resign or last election, I would not have ran against her. I think I speak for probably almost, if not all of the Anderson County Bar when I say we loved her. She was an excellent judge, very pleasant. I was kind of laughing to myself, not in a bad way, but when you were asking Mr. Terry about the stink eye, Chancellor Landrip could give you the stink eye just if he was having a bad morning. The difference really between her and Chancellor Cantrell was she was just so pleasant to everyone, and everybody loved going in front of her, and she was smart and made very good rulings. And so if we didn't have the Australia relocation, whatever you would like to call it, I wouldn't run against her. I liked her that much and respected her that much. I would have been happy just to keep on practicing.
All right, fast forward to a year, 18 months. We've heard from 2 great candidates already, and I mean, we got 2 more, I'm sure, that, and along with yourself. If you're not appointed, do you run for this position?
Well, that's a tough question in a couple of ways. I think if you're standing here this morning, if you're not seriously considering running, you might want to rethink your position, because next year is the presidential election and the primaries are in March. And so literally 13 months from now is 13 months from now is the primary election. So that means next month you should be able to be prepared to hit the ground running. And so is it something I'm absolutely considering 100%? So while I don't want to say definitively, because I think it'd be premature to make an announcement, but it is something that we are very seriously talking about doing.
Well, I've certainly enjoyed your presentation. I mean, no disrespect to the former chancellor. I just thought it was kind of odd. Just to run and then retire. I just thought, well, I would have liked to have seen you, Mr. Terry, Mr. Crutchfield, I would have loved to have seen you guys have an opportunity to duke it out in an election.
Yeah, just have an open election. Absolutely, and it was an odd, and I can say that some of the bar, even, we tried to talk her out of it, and she just decided that was the thing for her, and that was her next step in her life, and she was not going to change her mind. But we, you know, like I said, as far as a chancellor, you couldn't ask for, I think, a better judge.
I guess love would do that to you. You were great. I really appreciate your presentation.
Well, time is not going to permit me to ask you to enlighten us about the rule against perpetuity. So.
Oh, thank goodness.
So the circumstances are in your favor. But I do have one question. It's following up on Commissioner Perky's inquiry about injustice. And you were commenting about how people sometimes walk out, whether it's victims or people who've not won and think it's been unjust. And different judges have different styles, and I'm not going to distinguish between chancellors and circuit judges, but there are some judges that are quite ready to hand down a ruling. They're less ready to explain why, and it seems as if there might be a correlation between the litigants who don't know the system to just hear you lose, you win. That creates a sense that I wasn't heard. And what's your idea if you're sitting on the bench and you've had a bench trial and you've come to a decision, you're going to announce it? Are you going to explain why? Are you going to look them in the eyes and say, "Here's why I'm doing this"?
Well, I think obviously, if it was like a custody trial, of course, you have findings of fact that you put on the record and go through the statutory guidelines, and I think you could try to explain to them, maybe less in legal terms, but maybe here's what I base my decision on. And I think in a criminal matter, and I think I've seen judges do this, sometimes you have upset victims, in particular in the courtroom, and sometimes, you know, there's times to let them even come up and address the court. They have an opportunity to speak, so they at least feel like they've been heard. And then also, you maybe explain to them and maybe say, "I'm very sorry. I understand this is not what the family or the victims were expecting, but, you know, unfortunately, the Air Tennessee sentencing guidelines maybe only allow what happened here today." And so I think you try, and I agree with your statement. I think situations like that would help, and we do see cases where sometimes a judge issues a ruling, says adjourn, gets up, walks off the bench, and then the attorneys are trying to talk with their clients. So I agree completely with your assertion of that. I think it would be helpful.
Well, your answer is great, and thank you for your application, your presentation, a capricious piece of advice. If you do get on the bench, never say "I'm sorry." You know, you may be thinking it, but that's probably something you want to get out of your lexicon. Thank you.
Thank you.
To give you some idea about coming attractions we're going to do one more interview before we break for lunch. And so I want to apologize to Mr. Brooks that you're going to have to wait until after lunch, but I think that it's probably going to be best for us to do one more. We'll probably break for a half hour or so to get a quick bite and then come back. So my apologies, Mr. Brooks. And with that, we are ready for Ms. Crutchfield. Thank you for your patience. And I believe Mr. Waters is going to start the conversation.
Good morning. Thank you
Good morning.
for coming this morning. I feel like a broken record, but I received a lot of recommendations from the local bar, some calls on your behalf, and appreciated those. And I think I even discussed that with you in our meeting last Monday. We had a nice meeting in my office. Appreciate you coming by, and it was great to get to know you. I know our offices are maybe about a half mile away from each other, but we had never been acquainted, so I appreciated that opportunity. One of the things that you did mention in your interview that you're about to be an empty nester, and you've been married to your husband for 30 years, and while personally I've avoided that covenant for the last 35 years, I think you're 30 years, and I believe Mr. Brooks had 40. So those are certainly accomplishments. But you did mention that one of your things in your free time that you enjoy is travel. And am I correct that you've got a pretty important and special trip coming up next week that you're about to jettison off to?
I am. My son graduates from the Air Force Basic Training in San Antonio, and so my family will be going early next week, leaving for San Antonio to watch him graduate. We haven't seen him since January 10th, which is really hard. So we're looking forward and very proud.
Well, I think I speak from everybody in this body that we appreciate your son's willingness to serve this country, and of course all of our candidates' willingness to serve Anderson County. So one thing, so I did mention that you have an office in Knox County, but am I correct? A lot of your practice is not only just in Knox, but you live here in Anderson County, you work here in Anderson County. Can you kind of expound on that, your experience here?
Throughout my career, my practice has been all over East Tennessee, and when I was with Lautner, it was pretty much all over. Generally the Southeast, but the last 15 years, I've been primarily in East Tennessee in all different courts, administrative agencies, Court of Workers' Compensation Claims, federal court, Chancery court. My practice has not included criminal, but certainly willing to learn. It's been tangential into some white collar criminal matters. Those are more federal. But Chancery Court is certainly where most of the corporate clients and probate estates and the domestic relations cases that I've done in the past, that's where my practice has been.
And I may have gotten ahead of myself. Can you give us a little background of your practice? I know you've been practicing here in East Tennessee for a while, and you've got a lot of different types of law that you've practiced. Can you kind of walk us through your career and what brought you to be standing here today?
Well, my first law job was with McCord, Weaver, and Troutman, Chancellor John Weaver, before he was on the bench and before he was clerk and master, was one of the partners there, and I did a lot of bankruptcy and receivership work with him. Did estates, did business divorces, and once he moved to become clerk and master, I was doing divorces and business divorces because that's what got you into court. And so after I had the opportunity from one of the clients to go in-house briefly, and really I learned a lot, but really missed working with other attorneys, working in a firm, and had the opportunity to go to work for Lautner, Williams, Dooley, and Napolitan. And that was where I really feel like I cut my teeth on litigation, learned how to practice more jury trial work and that type of thing. Learned the importance of the rules of civil procedure, the rules of evidence, those types of things. Had some great mentors there with Dana Holloway and Tim Connor, and became one of the first female equity partners there. I then had the opportunity, I knew Ron Daves at Wimberly Lawson, and Tim Bobo had actually worked at Wimberly Lawson before, and I had talked because I enjoyed the employment law and HR and working with businesses and corporate on HR issues. They had more of a boutique practice in employment, labor and employment, and workers' comp practice. And Patty Wheeler, who was sort of a role model for me as a female litigator, and she was one of the few women in Knoxville that had a active litigation practice, and she was there at Wimberly Lawson, and so I moved there and did primarily employment, again corporate work and defense and all fairly broad, everything from commercial leases and a little bit of construction and to general liability, insurance defense, consultations. How do we, if you've got an EEOC charge or if we've got an investigation for a sexual harassment claim or things like that. Did a lot of consulting work, things like that. And then I was, after Ron Daves passed away, I was looking, I was talking with Heather Anderson, who is a friend from Etlaw, and they were looking for another attorney, lateral with experience. And I had always wanted to work with Heather, and some knew Tyler Chastain, of course, knew Bernie Bernstein, and knew Caesar Stair and all of the lawyers there and their reputation, and the opportunity presented itself. And so I'm at Bernstein, Stair, McAdams, and doing a little bit of everything, but primarily business and corporate defense and litigation.
And am I correct? You recently were a mediator approved. That's a new
I
venture
did.
when you obtained, but you haven't quite put into practice yet.
Just last year, I received my Rule 31 mediation training and approval to be a Rule 31 mediator, but haven't really had the chance or opportunity to establish a mediation practice. I have used my training, certainly, in almost all of my cases in some way or the other, whether you're working with clients or you're working with opposing counsel, remembering at the end of the day what you can agree on and what you can't, or can we mutually come to an amicable solution instead of years of expensive litigation. What's in the best interest of our clients? Those type of things certainly are useful tools in training to have.
So one of the things we discussed, and I appreciated, was your focus on being a team player. And I know that we talked about being ready on day one, not only with practice areas, but with taking the bench and not only handling your courtroom, but being as Anderson County Courts as a whole. And you mentioned a good working relationship with Judge Spitzer and Clerk and Master at General Sessions Court. Can you tell our committee here what kind of synergy how you would play into that role and promote a team aspect of the court system?
Well, the judge is only one part of one part of the administration of justice. And lots of times as lawyers or as litigants, you don't see what goes on behind the scenes to make everything work. Having a good judicial assistant, clerks, a clerk and master, most of the administrative details, the magistrate courts, the other courts that have, the juvenile court is as a chancellor, you would hear appeals from magistrate courts and juvenile courts. And there's currently, because of Chancellor Cantrell's leaving, certain matters are being heard by the General Sessions Court, and Judge Spitzer is hearing certain matters that need to be taken care of. So I think it's very important that the Chancellor work together with everybody, from the court officers to the clerks to the other judges, so that everything runs smoothly and as little drama as possible.
I know Mr. Forster mentioned this, but if given the opportunity or to take criminal cases from Judge Spitzer's docket, if there is a conflict, is that something you'd be comfortable with, or at least getting up to speed on if called
I would
so do?
definitely be studying and getting up to speed. That has not been my wheelhouse or experience, but I would certainly, I was prepared when I applied for the circuit court position to learn, and knew that that would be a big learning curve. I am still willing to learn as much as possible. Don't want to be stepping up on anybody's turf or anything like that, but certainly would be willing to work with Judge Spitzer on things that he might need help with or that I could assist with.
Well, Mr. Bobo kind of took a little bit of my this next question, but I know when we had our discussion, you mentioned your importance of being able to go head to head with an attorney and then going to, grab a libation afterwards with your opposing counsel. And I believe Mr. Bobo mentioned that in your opening statements that is possible, and I gave that example. How do you translate that into being, a judge in these cases where you have to remain impartial, but also, promote that type of candor in the courtroom? I guess to rephrase that, how would you preside, in a day in your court, how would you handle yourself or want the attorneys in your courtroom to handle themselves?
Well, I would want to be prepared, and I would want them to be prepared, and I would want to be prepared, and to make clear the expectations as far as in the courtroom. It's a matter of applying the facts presented to the law, and that doesn't matter whether I know you and I'm friends with you. This is a matter of the evidence presented, and this is the law. This is the findings of fact. This is my conclusions of law. And at the end of the day, I hope that I would be clear enough and concise enough that they may not agree with me, but they would know that it wasn't a matter of whether or not I was friends with you or whether or not we knew each other, or a disagreement about the law is what keeps lawyers employed.
Well, in your courtroom, is there anything, I know we've talked about unwritten rules, is there something that you wouldn't tolerate? Is it tardiness? Is there kind of a pet peeve that you believe, and maybe getting ahead of yourself, but if you were presiding, what's something that going into your court you should know to either avoid or to either be on time or be prepared, or kind of what's your biggest pet peeve that you would want someone in your court to abide by?
I think the expectation is that you would be on time and be prepared, know your case. Something that sort of frustrates me is when I have spent a lot of time on a case and I'm coming into a courtroom and nothing I've filed has been read, or opposing counsel has not responded in writing and comes up the day of the argument and you feel like that they've not produced or raised an issue before you get to court. Those kinds of things, not knowing the case or the case facts, those would bother me, but it would irritate me. But again, like Mr. Forrester and some of the other candidates have said, I don't think you make those, the time and the place during the hearing is not necessarily the place that you call them up and say, hey, what's going on? But I think letting people know your expectations through either court rules or certain forms. I know that scheduling orders in Knox County have been very helpful in letting litigants know what they need before they get a trial date. And so there's not a continual, here's your deadlines for discovery. Those type of things, transparency and policies and procedures let litigants know what's expected.
Judge Ellis mentioned this earlier in his opening remarks, that you're very service-minded, that you're very, you're kind of a joiner. There's a lot of groups that you're in, that you like to be an officer of. If you do take the bench, do you envision yourself using that as a way to continue to serve outside the courtroom, and what kind of service opportunities would you still continue to do while serving on the bench?
I think children and animals are near and dear to my heart, and so I would still think that I would be involved in supporting organizations like CASA that support abused and neglected children, and the At-Law's been very involved with the YWCA and the services that they provide to battered and abused women, and I would hope to continue some of those functions and service projects.
Okay. And last question on a lighter note. I'm not sure what the nepotism policy is for this court, but I know you mentioned that your husband has an employee that's very dear to him. Do you believe that you would employ Leo in your office in any type of role?
Oh, no, I don't think I could employ Leo. Leo is our dog, actually my husband's dog, because, and Leo would tell you this too. He comes to me to be fed, and at night when he's ready to go to bed, but the rest of the time he's going to work at Crutchfield Surveys.
Okay. No further questions.
Well, I remember you from last time very well, and you comported yourself as well this time. Do you often talk to Leo on a one-to-one basis? Just thought I would ask the obvious question here.
I do talk to Leo.
Now, does he talk back?
Well, no, but he's got very expressive eyes.
Understood. No further questions, please.
Commissioner?
Thank you, Mr. Chairman. Ms. Crutchfield, I too remember you from a couple of years ago, and Teddy Roosevelt said the credit belongs to the person in the arena. And you've been in the arena both professionally and personally in a lot of different areas, and you're to be credited for that. So I wanted to say that you're qualified for the position. There's no question about that. I just had a thought, though, thinking about Anderson County being its own judicial district, and you have Judge Spitzer and then the Chancellor. Let's say on a Saturday afternoon, the Sheriff's Department needed a search warrant, and Judge Spitzer was out of pocket. Do you have two sessions judges here?
Yes.
They couldn't reach the sessions judges. It's just one of those deals that they couldn't get a hold of anybody. And they get a hold of you, say, Judge, we need a search warrant. Can we come by your house? Would you be open to that?
Yes.
Okay.
Yes, although traditionally, the Chancellor has not heard any criminal cases here in Anderson County. That's been more of just a tradition amongst the judges, the trial judges here, but they have concurrent jurisdiction, and that was one of the things that I had talked to Sheriff Barker about in the past, was that there could be times in that he had to call Chancellor Cantrell in the past for assistance with those type of things. So I would consider, as a trial judge of Anderson County, doing whatever needed to be done to serve Anderson County.
I understand. One more question, and just, again, I'm not looking for a certain answer, but I'm interested in how you feel about the death penalty and Tennessee being a death penalty state. I'm just interested in your thoughts on the death penalty.
I think that it is a rare a penalty that's necessary in rare cases or appropriate in rare cases. And I think that where there's a particular crime that is so heinous and terrible, and there is absolutely no doubt amongst the jury of 12 that the death penalty is appropriate. It's the law of the state of Tennessee. I think of cases like the Christian Newsom cases and folks like Jeffrey Dahmer and things like that. I think it's rare. I think you do have to look at it. I think it's certainly the most heinous crimes, but I wouldn't, in those cases, I would not have a problem upholding the jury's verdict for death penalty.
Well, thank you for your application. Thank you, Mr. Chairman.
Thank you.
Good afternoon, Ms. Crutchfield.
Good afternoon.
Good to see you again.
Thank you.
I have no questions, but I want to thank you for participating in this process.
Thank you.
General?
Thank you for your application. A couple of quick follow-ups. Search warrant, it's 3 o'clock, 3 a.m. on a Saturday morning.
3 a.m.
You're making it hard.
Still available, the sheriff and DA or whomever comes by your house for that review?
I would think that if they're calling me at 3 a.m., it's pretty important.
There was discussion about preparation for court, and I just want to turn it a little bit, because if I understood your answer, you talked quite a bit about what the litigant should do. But what does a chancellor or a judge, circuit judge, whatever, what is that role in terms of preparing for court or for a hearing?
I would read everything that's filed. If it's something that I'm not as familiar, an area of the law that I'm not familiar with, or I see a particular issue that I think is unique, or there's certain factors in the motions or the pleadings that have been filed, I'm going to look up and see what the case law is. I want to know myself. One of the things, I've had the opportunity to teach pretrial litigation at UT this past fall semester, and looking at the rules of evidence and the rules of civil procedure, you see things so much differently in a different context. And so I think it's important to go back and read the rules and read the law, to be prepared and see things might look a little bit different given a different set of a different fact pattern, or a little quirk here or there that makes something unique. So I would read everything that was presented to me, and I would also do homework to make sure I was prepared to ask the right questions and to make the appropriate findings of fact and rulings of law.
Appreciate it. Thank you.
Thank you.
You're out of order.
It's a newbie.
I don't have any questions, but I do have a comment. I'm very impressed by your career. Your application it shows the level of commitment that you have to this community and to this process, and I'm grateful that you're here, and I wish you all the best.
Thank you.
Your turn.
I'll wait to be called.
Commissioner Lancaster.
Thank you. I also remember you from before, and welcome back, and so grateful that you put your application in for this. If memory serves, and that's a dangerous thought, but
It is certainly
the
dangerous.
conversation last time was a little bit on criminal law. I'm looking at your percentage of all the work that you're doing now, and clearly you have a broad breadth of practice over the years and currently. What would you say the part of Chancery would be? I think you might have mentioned this a little bit. That would be the one you'd have to get your lesson up on the fastest, would be the least experience you have in that particular area of Chancery. And then second part, let you go ahead and do that too, is how will you attack it?
Well, one of the things that I would want to brush up on is injunctions, because I've only been involved in a few of those, requesting emergency relief and temporary restraining orders and things like that. And one of the last ones that I was involved with was in front of Chancellor Weaver, and who I had clerked for. And making sure that everything, that I was up to speed on all the requirements for notice and for, it's sort of like a mini trial ahead of time. So I would want to get up on that, because that's something that you don't see every day in a routine matter. I'd certainly want to brush up on the latest in, while I have not actively practiced in domestic relations area and child support guidelines, I have worked on appeals in domestic relations cases at Bernstein Stair, and I would want to make sure that I was up to speed on all of the latest. I have spoken with Magistrate Joe Clark about the interplay with the 4D child support program and how that works with the Chancery Court. So it's important to me that I'm up to speed, but also rely on the input of the other people that I'm working with, whether it's probate or, while I'm not one of those that this is the way we've always done things, or if it's not broke, don't fix it, I'm always looking for ways to make the process or things better.
Thank you. No more questions.
I've been practicing 22 years, and I'm still searching for a judge to say I was a dream. I want to know
And
what
you've
your
got a
secret
long
is.
time to
I want to
look.
know what your secret is, because Judge Elledge, I mean, and I'll say this, he wrote us an awesome letter too about you. He said he's been doing this 46 years, 16 years on the bench. These are the things he said about you: that you're honest, you got high integrity, your moral values are beyond reproach. I mean, these are like some impressive, that's impressive.
It makes me want to cry.
Well,
I'm just so touched.
The hairs on my arm are standing up just saying it, because I appreciated that. And I want to know what your secret is. I want to know what are you doing that I'm not?
Everything.
That may
Sorry.
be the case.
We don't have time for that.
No, you don't have. No, that's what I love about doing this, is coming to these counties and hearing these stories and hearing the fine things that people say. I watched your husband as you were answering the death penalty, and he was on the edge of his seat, interested, and I've appreciated your presentation and the things, the way you've answered the questions. I wasn't able to come to the last committee meeting here. I can't remember what I had going on, but something for me to miss. It must have been a kid-related deal or something. But I've appreciated your application and the way the folks have resonated, and what Judge Elledge said about you. That was very kind. I think you'd be you're an excellent candidate, and I think you'd make a great judge, and just wanted to share that with you.
Thank you.
That's all.
Well, It's hard to follow that.
Really?
Well done.
I just think she, yeah, I just like, I've enjoyed it, I really
I wanna
have.
follow up on just a couple of things. You know, the first is that when you sit on a bench, you've got law and you got facts. And it can be very clinical if you shoot, and sometimes it has to be to keep your objectivity. But certainly on the domestic side, there's another adjective that I don't normally use, but I'm going to use today, or noun, and that's empathy. And I'm curious, you had a transition from social work to law. That tells me there's empathy in there somewhere. But then in your application, you mentioned some of your work as a guardian ad litem, and you talked about 3 sisters, 3 little girls. And you know what they're doing now?
I don't. The Church of Latter-day Saints in Utah came and the Department of Children's Services worked with their program to get them back. Their mother had divorced or and was no longer with the church or the breakoff sect that their father was a part of. And so it was my understanding they were trying to reunite the mother and the children. But after they left the state of Tennessee, that was the last I heard. They would be in their 30s now.
It just, there's no right answer to this. I mean, each judge for him or herself has to decide where this fits. Where does empathy fit in for you?
I think I'm an empathetic person, just by nature. So I want to work as much behind the scenes and in other service organizations to address the things that law can't do. There's certain things that courts can't fix. In fact, there's a lot of things that come before the courts that are driven by non-legal factors. And while I can be very empathetic, I also recognize the limits of the courts to address certain things. And I would hope that the clerk's office and the court system would have, you know, have resources there for people, like the Family Justice Center, like the drug courts, like, you know, CASA, those types of things to help where the law just can't fix.
Great answer. Thank you. We appreciate your application. We are going to adjourn at about 12:15, and we're going to try to come back as close to 12:45 as we can.